Good afternoon. Welcome back to a second show of the day. Still got a lot to talk about, awaiting an appeals decision. So we're going to see what happens. What's up, Myron? Hey, Jim. Good to see you. What's up, Red? How are you guys? So, folks, if you're joining me on YouTube and Facebook, make sure that you speak because I can't see when you join. I can only see when you speak to me. So, good afternoon, Pooch. What's up, J Talk? Hello, Lance. What's up, Dorothy? How are you? TikTok looks really weird. Hey, Auntie Winnie, what's up? Hey, Sarah, what's up? Inger, how are you? Hey, Lisa, good to see you. What's up, Candy? Hello, Rachel. Hello, folks. How are you this afternoon? You guys good? Thank you, Farah. Welcome back to you too. Hey, Laura, what's up, Dax? Hey, Mama for Coop. Hey, Veronica, what's up? How are you guys? Yep, it was a good deal. G, it was needed, right? What's up, Wandy? Good to see you as well. Hey, Bugaboo, what's up, Cheryl? Hello, you don't know me. What's up, Blue Honey Pot? And oof, it went really fast. 2409. Hey, Sandra, welcome back. Good to see you over in Facebook. Hey, Karen, how are you? Hey, Trace in Blue Nevada. What's up, everybody? Y'all doing good? Are y'all doing okay? What's up, Renee? You doing all right as well? Good afternoon, Dax. Did anyone else watch the hearing? I did not. And so we are gonna check it out a little bit because it is on their website, right? It's on YouTube. So we are going to check. Hey, Phantom, how are you? What's up, Lisa? You doing good? Good to see you as well. So we're going to kind of dive right in and see what we've got a lot to talk about because we should have a ruling today. I did read an interesting article. What's up, Lady MMQ? I did read an interesting article about the arguments that were put forth before the court today. And it's interesting. Hey, Danielle Denise, it's good to see you. You're exhausted. Your brain is done for the day. I wish mine was. Hey, Natalie, good to see you as well. I'm sure you've probably got your sage close by. Yeah, well, Monica, remember, we don't do worried here. We can be concerned, but we don't do worry here. So real quick, hey, Kimmy, good to see you as well. I'm going to check the Ninth Circuit, and we're just going to pop and see if they stream it live. 14 minutes ago. Let me just take a peek. Yeah, because there are 3 lawyers. Okay, so here we go. You ready? Do you guys want to listen to some of the arguments? You guys want to do that? Because I've got it right here. Hey, Natasha, good to see you. So it is the argument. So, okay. So last week, Gavin Newsome won in the state of California. They won their court decision with reference to the National Guard being federalized by the Trump administration. And so that was being heard today by a panel of 3 judges in the appellate court in the Ninth Circuit. Hey, Bella. Well, never mind. The Ninth Circuit Court of Appeals. And so what we can do, hey, Denise, good to see you over there. What we can do is we can take a listen to the Court of Appeals and kind of see, kind of how those arguments went and what we heard, right? Let me also say this to folks. So if you are new to my space, let me go ahead and tell you this, okay? In here, I only ask for 4 very, very, very simple things. I ask that you be respectful. I ask that you do not use slurs of any kind. I ask that you do not spam my comments. In other words, say what you got to say, but not 5 times, not 6 times. And then the last thing is that I ask that you do not type in all caps because all caps are reserved for my moderators and for a couple of my folks that are vision impaired. Yep, we just came back, Uka. So what I'm going to do is I'm actually going to play footage from the hearing. That way we can hear the arguments that were made before the appellate court. It looks like it ended just about 14 minutes ago, something along those lines. So we're going to take a look and see what we think. Okay, right? Okay, Mandarific. Good to see you too. What's up, Athena? All right, folks. So let me get going. And on you guys' side, TikTok, you'll know that what's up, Cam? Hey, Mom with Goals. So we're going to take a listen to some of that hearing so that we can hear the arguments. You can add a live to your story. I don't know. I guess. I don't know. But we're going to listen to the arguments made before the court. I think it's one of the most important things that we can be listening to today. If it ended, was there a ruling or no, the ruling will come later because it's a 3-panel judge, right? So the attorneys argue all of their points, but before the 3-panel judge, the three judge panel. Dear Lord, my face doesn't want to work. And then they will issue their decision. Last time, remember, it came around 8 o'clock our time, around 8:30 our time, and 5:30 Pacific time. So we're going to see what it is. But this is what I'm going to do. I'm going to share it with you guys, and we'll listen. And as we listen to their arguments, I think the other thing that we would do is we will pause when we hear certain parts that are worth making note of, and kind of talk our way through it. If you guys are game for that, I am definitely game for that, because I think this is beneficial information. What's up, Tiny Dreamer? I prefer to do this than to get a bunch of people together and guess about what they're going to do. I just think listening to the facts and talking about them is our best option. Okay, so that's what we're going to do. That's what we're rolling with today. Again, if you're on Facebook and YouTube, remember that you've got to speak, or I can't see you, and then I won't be able to say hi. What's up, Veronica? Good to see you. Yeah. So Denise, we talked about AI quite a bit earlier this morning. And we talked about a documentary that I think everyone should watch, which is called, After Truth, right? It's called Disinformation and the Cost of Fake News. It talks a lot about technology abuse, and things like that. So we talked about it in my live earlier today. So just because you join me and I'm not talking about a particular subject on that time doesn't mean we don't ever talk about it. But I appreciate any and all suggestions and recommendations. Okay. What's up, Winn-Dixie? Good to see you. Hey, Beach Bum Wannabe and Gemini. Hello. All right. So here we go. Let me pop in here and get this sucker going. Let me pause it. And here we go. Hey, Robert McKinney. Good to see you. All right. So you guys can see it over here. You guys are going to listen over here. Hey, Jen Bet. What's up, Robin D? Hello, A Marva Granny. Good to see you, Laura. Hey, Bubba Head. All right. So here we go, guys. All right. So just try to pay attention. I don't get to control how great it sounds because it is from their feed. No worries, Natasha. Here we go. You ready? Here we go.
United States Court of Appeals for the Ninth Circuit is now in session.
Good morning. I'm Judge Bennett, and with my colleagues, Judge Miller and Judge Sung.
Everybody, the sound is okay for you?
We have one case on the argument calendar today. Governor Gavin Newsome et al. Versus President Donald J. Trump et al. The oral argument is set for 1 hour, 30 minutes aside. And let me just make sure with counsel, Mr. Shoemake.
I'm going to pause it for just a second, y'all. I'm going to do a very, sorry, but my mother would absolutely cuss me out if I did not tell her to go join this live and listen to the appellate court hearing. Hold on 1 second, y'all. Yes, I really stopped the live so I could tell my mama this. Hold on. I don't want to get cussed out. 1 second. Hey, so listen, I'm live, but I wanted to let you know that if you want to join the live on Facebook, I am listening to the argument before the Ninth Circuit today about Newsome and Trump. So if you want to hear the actual lawyers argue it, join the Facebook now.
Join what now?
Go to Facebook and watch my live. I'm playing the arguments before the appellate court in San Francisco.
Okay.
Okay. All right. Bye. Yeah, y'all just don't know. I would have got cussed the hell out. What do you mean you played it? Ooh, okay, here we go. Sorry, y'all. Yeah, Natalie, got to take care of my mama. So here we go.
United States Court of Appeals for the Ninth Circuit is now in session.
Good morning. I'm Judge Bennett, and with my colleagues, Judge Miller and Judge Sung, welcome to the Ninth Circuit. We have one case on the argument calendar today. Governor Gavin Newsome et al. Versus President Donald J. Trump et al. The oral argument is set for 1 hour, 30 minutes aside. And let me just make sure with counsel, Mr. Shoemake, can you hear us?
Yes, Your Honor. Good afternoon.
Good afternoon. Mr. Harbord, can you hear us?
Yes, I can.
Great. All right. When the appellant is ready to proceed, you may begin.
Thank you, Your Honor. May it please the court, Brett Shumate on behalf of the federal defendants from the U.S. Department of Justice. If I may, I'd like to reserve 5 minutes for rebuttal.
Okay.
Thank you. The court should immediately stay the district court's extraordinary order because it interferes with the president's commander-in-chief powers based on an erroneous interpretation of the applicable statute. It upends the military chain of command. It gives state governors veto power over the president's military orders. It puts Article 3 judges on a collision course with the commander-in-chief, and it endangers lives. Even California concedes that there is ongoing civil unrest in Los Angeles. But this is no ordinary civil unrest. As we've explained in the Santa Cruz Declaration, federal personnel continue to face sustained mob violence in Los Angeles, expressly aimed at preventing federal officers from enforcing federal law. Unfortunately, local authorities are either unable or unwilling to protect federal personnel and property from the mob violence ongoing in Los Angeles today. Under these conditions, the president acted well within his discretion in calling up the Guard. Based on his determination that the violent riots in Los Angeles constitute a rebellion against the authority of the United States, it rendered him unable to execute federal laws. Yet the district court improperly second-guessed the president's judgment about the need to call up the Guard in order to protect federal property and personnel from mob violence in Los Angeles.
Mr. Shumate, so I want to start by drilling down on one aspect of our standard of review. And I'm going to be discussing subsection 3 only of section 12406. And you just said the president acted well within his discretion. Again, just as to section 3, is it the United States' position that the court has no role at all in reviewing what the president has done in calling forth the militia under subsection 3? Or is it the United States' view that the court has a limited role and it needs to afford the president very substantial deference, or is it something else in deciding whether the requirements of subsection 3, inability with the regular forces to execute the laws, is met?
Thank you, Your Honor. Our view is that this statute commits the decision whether to call up the forces to the president's unreviewable discretion. So no, there's no role for the court to play in reviewing that decision. And I think it's important to note that the statute here is very similar to the statute at issue in the Martin case that we've cited, the Act of 1795, which had a similar structure. It had the whenever clause followed by a delegation to the president to call up the militia. And in that case, the Supreme Court in 1830 said, if that's a...
Can I just freeze for a second? Okay, hold on, fans. Oh my God. Because I need for you all to just see the judges' faces. Hold on, YouTube and Facebook. I need for you all to see the judges' faces at his response. Because sweet baby Jesus, I just am like, holy hell, what are you talking about, people? Okay, yes, honey. Yeah, baby. Ask Dominic to help you because he knows he needs to help you while I'm working real quick. Okay, so I just want you, so you can see, so TikTok will get mad at me if I play the video like the whole time. But I am playing the video on my stream that is on YouTube and on Facebook. Okay, but I just need you all to see these two faces right now. So just, okay, y'all see there? Look at her. Look, he said, what in the holy hell? See this dude right here? And look at her. She said, really now? Really now? I am crying at these expressions on their face. I am absolutely crying at the expressions on their face. Okay, so I'm gonna go back just a little bit so that you all can hear this question, and and what they're saying, because literally this is what they did argue. I do want to say this to you all. This is what the Trump administration did argue, was that the court doesn't have the right to review what he does. These people are the 3 judges that are the judges for the appellate court in the Ninth Circuit. So they are the ones that will be making the determination whether to overturn or uphold the decision of Judge Breyer. Okay. And so this guy right here, this is the attorney for the DOJ for the Trump administration. And this guy right here is the attorney for Gavin Newsome. And so I just want you to watch when he finishes and what this judge, the question when he asks the question, then I'll turn the camera back around.
The court has a limited role.
Hold on.
Within his discretion.
Oh, my Lord.
Explained in the Santa Cruz declarations, federal personnel continue to face sustained mob violence in Los Angeles, expressly aimed at preventing federal officers from enforcing federal law. Unfortunately, local authorities are either unable or unwilling to protect federal personnel and property from the mob violence ongoing in Los Angeles today. Under these conditions, the president acted well within his discretion in calling up the Guard, based on his determination that the violent riots in Los Angeles constitute a rebellion against the authority of the United States that rendered him unable to execute federal laws. Yet the district court improperly second-guessed the president's judgment about the need to call up the Guard in order to protect federal property and personnel from mob violence in Los Angeles.
Mr. Chairman, so I want to start by
he was going to ask too
on one aspect of our standard of review, and
judges,
I'm going to be discussing subsection
Trump
3
lawyer,
only,
Newsome lawyer,
section 12406, and you just said the president acted well within his discretion, and again, just as to section 3, is it the United States' position that the court has no role at all in reviewing what the president has done in calling forth the militia under subsection 3? Or is it the United States' view that the court has a limited role and needs to afford the president very substantial deference? Or is it something else?
Now watch their faces when he says something.
The requirements of subsection 3, inability with the regular forces to execute the laws, is met.
Thank you, Your Honor. Our view is that this statute commits the decision whether to call up the forces to the president's unreviewable discretion. So no, there's no role for the court to play in reviewing that decision. And I think it's important to note that the statute here is very similar to the statute at issue in the Martin case that we've cited, the Act of 1795, which had a similar structure. It had the whenever clause followed by a delegation to the president to call up the militia. And in that case, the Supreme Court in 1830 said, that's a decision that's committed to the president's discretion. It's not for a court to review that decision. The plaintiffs try to make out that decision as an outlier, but of course, there have been many cases since then involving unreviewable decisions committed to the executive. The last we cited is the Dalton case.
So is it your view?
He wanted to ask something again.
The president or a future president simply invokes the statute, gives no reasons for doing it, provides no support for doing it, and there is nothing which would appear to a court to justify it.
No, there's no decision yet.
Still has no role at all in determining whether the president, this hypothetical future president, correctly invoked subsection 3. No role at all, even if the president gives no reasons and there are no facts offered by that president to support that president's decision.
That's correct, because if the statute is unreviewable, it's unreviewable. Now, I point the court to the last section of the decision in Dalton, where the Supreme Court recognized, yes, Marbury versus Madison says the court decides what the law is, but it also respects that principle when a court recognizes that when a statute is delegating broad discretion to the president, that respecting that also is a judgment that a court should respect. It respects the separation of powers when Congress delegates that decision to the president. But I think, Your Honor, you're speculating about harder cases down the road. This is an easier case because there are facts in the record here that strongly support the president's decision that there was a rebellion and that the president was unable to execute federal laws under the third prong that we're focused on here today.
Okay, so quick pause just so that everyone is clear, okay? Quick pause. So what you have to understand, for those of you who are asking, is no, there's been no decision yet. This is the argument that took place before the court today. The top row are the 3 appellate court judges. The bottom, like left for me, which may be bottom right for you. So this guy right here is DOJ. And this one over here is going to be for Newsome's attorney. Now, here's what's interesting. The reason that this judge is asking about future presidents and what they would or wouldn't be able to do is because the judge, of course, understands that this decision will set precedent. And the DOJ attorney is trying to say, don't worry about what happens later. Like, this is just right now. Don't worry about it. Like, it's just this one. And then I just look at them like, what in the absolute holy hell are you talking about? So TikTokers, I will go back and forth on video with you so that TikTok doesn't ding me for playing the video. But YouTube and Facebook, you're able to watch it this entire time. So the decision most likely is going to come down today. The last time, John Tavius, it came down at about 5:30, 5:45 Pacific time, which is about 8:30, 8:45 our time. So here we go. I'm going to start playing again. So just check it out and listen. And for those of you all surprised that they doubled down, I need you to remember that the DOJ, they absolutely doubled down, and they did the last time. And they did in all of their cases concerned with January 6th. All right. And that's why several of them can't practice law today. But here we go.
And what if, would your answer to Judge Bennett's question be the same if in the hypothetical the president articulated a justification for his action that was not one of the enumerated purposes in 12406?
Again, I think I would give you the same answer, Your Honor, that if it's unreviewable, it's unreviewable.
Oh, shit.
It's also acknowledged, yes, there can be cases where discretion can be abused, but in that situation, there are other checks on the president through the political process. It's not for a court to exceed its authority just because there may be hypothetical cases in the future where the president may abuse his authority. The president hasn't done that here.
No, go ahead. So
suppose that we don't agree that the
I'm
question
going to go back and forth with the camera for you guys.
What does it mean for the president to be unable with regular forces?
Yeah, but Rain, if I play it the entire time, TikTok will ding me. So I'm going to go back and forth with the
regular
camera.
Forces on the ground in Los Angeles aren't adequate and sufficient for him and his judgment under the Take Care Clause of the Constitution to carry out the laws and enforce the laws. And then here, I think the Santa Cruz declarations make that pretty clear. Paragraph 7, for example, talks about specific immigration enforcement actions that were unable to be accomplished because of the mob violence preventing ICE officers in Los Angeles from carrying out those actions.
But in the normal course, the level of resistance encountered by federal law enforcement officers is not zero, right? You go to arrest people, and sometimes they don't want to be arrested, and they run away or even resort to violence, and sometimes they get away. So does that mean that the president, every day is unable to execute the laws, and he could invoke this, whenever?
Well, I think, let's remember, the president also takes an oath to support and defend the Constitution. He has an obligation to take care that the laws are faithfully executed. And I would point the court to the language about the regular forces, right? That, I think, provides some guidance to the president about, look, if regular forces are capable of addressing, the one-off situation where there's resistance to federal authority, then there's no need to invoke this statute. But what we have here is a documented record of sustained, ongoing mob violence continuing through this past weekend in the supplemental declaration that we filed that explained there were 1,000 violent protesters this past weekend outside the federal buildings, and it required the National Guard. They were essential to protect that building from the breaches that had occurred the prior weekend.
So is the United States still arguing that this case is governed by the political question doctrine?
I think that's an alternative argument. the argument we're pressing today and in our motions papers are, the Dalton and Martin line of cases that this statute confers unreviewable discretion on the president.
Well, with regard to your alternative argument about the political question doctrine, are you aware of any Supreme Court or Court of Appeals case in which the political question doctrine has been applied to a claim alleging that the executive branch violated a statute?
Yes. So, but if I do this, y'all, it gets super big.
I don't know off the top of my head, Your Honor. Again, the argument that we're pressing today is based on Dalton and Martin, that the statute here confers unreviewable discretion on the president. We're not, at least for purposes of this motion, we're not pressing the political question doctrine.
Are you familiar with the 1932 Supreme Court case of Sterling versus Constantine?
I'm not familiar with that case, Your Honor.
All right. I would just note that in that case, in discussing this power of the president and prior cases, the court said the nature of the power also necessarily implies that there is a permitted range of honest judgment as to the measures to be taken in meeting force with force and restoring order. And I'm not going to ask you further about the case since you're not familiar with it, but I take it the United States' position, again, in answer to Judge Miller's question, is even if we reject your view that it's absolutely unreviewable within the language I just read, it's the United States' view that it fits, the facts here fit comfortably within that language.
I think that's right, Your Honor. Again, so even assuming this is not a political question and that this is something that wouldn't fall within that line of cases, there is this line of cases, Dalton, Martin, involving statutes that delegate broad discretion to the president. There's a long history of courts not reviewing the president's discretionary decision.
That's Trump
Now,
attorney.
according to the language of this particular statute, it says the president may call into federal service members and units that he deems necessary, right? So that is an express delegation of Congress's power to call up the militia to the president.
Well, it's in such numbers as he considers necessary, right?
Correct. So the president has the discretion to decide what level of forces are necessary to counter the threat. And the threat is in the last phrase of that first sentence, necessary to repel the invasion, suppress the rebellion, or execute those laws. And in the president's judgment, 2,000 National Guardsmen from California are necessary to execute the laws in California. And the record bears that out, based on the fact that we have declarants from ICE explaining that the National Guardsmen are essential right now to protect the federal buildings from additional breaches and violent rioting involving fireworks, Molotov cocktails, concrete chunks being thrown at ICE officers who are simply trying to prevent individuals from interfering with enforcement operations and trying to breach the buildings.
So suppose that we had a hypothetical where suppose there was no violence, no organized opposition at all. Everything is calm in Los Angeles. And the president says, I've decided that there is a numerical target for the number of removals I would like to have. And with the number of ICE officers that I'm able to hire using the funds that Congress has appropriated, I can't hit that target. Therefore, I find that I'm unable to execute the laws, and so I need to call up the National Guard under Section 6. Setting aside, I understand your first line argument that the judgment is completely unreviewable. Do you think that would meet the definition of unable to execute the laws?
It certainly could be. Again, it would fall within the president's discretion based on the facts available to him.
So I hope that everybody caught that question, because that question is fan-fucking-tastic. Because, okay, so listen, there has been talk about this number, that there is a quota of deportations that Stephen Miller would like for the Department of Homeland Security to hit. And there is speculation that they are not achieving those numbers. And so what this judge has asked is, okay, so let's just say hypothetically, everything is peaceful, right? 3,000 a day. And so this judge is saying, well, okay, so what if everything is peaceful? If everything is peaceful, everything is cool. However, you have this quota that you all have set. right? For the number of deportations that you want to hit. And with the number of ICE agents you are able to employ using the funds that are available. And guys, remember, we already know that the Department of Homeland Security is running out of funds. They are going to run out of money about 2 months before the end of the fiscal year. And so he's saying, listen, you're not able to hit that number with the number of ICE agents you're able to get with the funds available to you. Could the president then just arbitrarily say, you know what? I need these 2,000 National Guard bodies to do what this, 500 ICE agents can't do, right? That's the question. And this dummy actually said yes. Sweet baby Jesus. But here we go.
This is not reviewable, then that would be a decision that the president could make. And if it's an abuse of that authority, there are measures or means by which the other branches, Congress, can check that decision. But I think the conditions also suggest some type of intervening event rather than an election, right? Like an invasion in the first prong suggests there's some type of activity that interferes with the security of the United States. The second prong, rebellion that rises up. The third prong, some external force or activity, right? That requires the president to act, not an election. But again, I think that would be within
the mere dissatisfaction with the level of the regular forces that Congress had provided would not be enough.
This was just a little bit ago.
Well, I wouldn't want to concede that, Your Honor. I think that would be the president's decision based on all the facts available to him, and the record may support it in a particular case. But obviously, that's not what happened in this case. The president acted.
So, Council, let me ask a question based on Judge Miller's hypothetical. So let's. But let's.
All right, Civic, thank you.
Let's take a look at the facts that Judge Miller posited, and let's say that the problem was limited to California. That there was nothing to suggest that the problem was beyond California. In your view, if a hypothetical future president made the decision to call up in response the militia of every state.
Listen at this.
And the District of Columbia, so 51 militia. Would it also be your view that that decision by this hypothetical future president would be entirely unreviewable?
Yes, because the statute says the president may call into federal service members and units of the Guard of any state in such numbers that he considers necessary.
This is why this is the test case, you guys. Do you understand why this is the fight that they wanted to have? This is the argument that they wanted before the court, okay? Because this is the end goal, is for them to be able to say that he controls absolutely everything when it comes to the Guard and federalizing those individuals who actually belong to the state. And so this is what everybody needs to understand, that this argument is truly about. This argument isn't just about, can Donald Trump, is there really a riot? Is there really a rebellion in LA? That's not what this is about. This is about, can they finagle this and get this to where this is a precedent for unquestionable, unreviewable presidential power. That's what everybody needs to understand. That's exactly what the Supreme Court decisions goes. What are you talking about? Hold on. TikTok is telling me something. I don't know what it's talking about. Wait, sissy, please. I told you guys, they're not going to want me to show the video all of that time. And so they are pissed. And if I show, I don't know why other creators can show the videos all the time. TikTok does not like for me to show videos all the time. So just telling you, you're going to have to see my face right now because TikTok will absolutely get me. Thank you, El Gordy, for gifting. Maybe TikTok will like me because of that. But anyway, so that's what this is about. And this is where the danger, I'm going to play it, Beck, so you're going to be able to hear it. Absolutely. But this is where the danger lies. This is what the Supreme Court case regarding presidential immunity was about as well. And what people need to remember, appreciate you, Donoski, is that he does not have blanket immunity. I really want people to understand that. He has presumptive presidential immunity, but it is not all inclusive of anything that he does while he is the president. That is not the case. So we all need to remember that. But let's hear, he actually said yes, because that's what they want. They need this on the record to see if they can get what they want. So just listen.
An express delegation that couldn't be any more clear that the president gets to decide how many forces are necessary to quell the rebellion, to execute federal laws. But again, bringing it back to this case, of course, that's not what he did in this case. He only called up 2,000 National Guardsmen. The Secretary of Defense found it was necessary to call up an additional 2,000. And the facts on the ground have justified that decision. Those guardsmen are necessary on the ground today to prevent breaches of the federal buildings, to protect ICE officers when they are conducting their law enforcement operations. The guardsmen are not conducting law enforcement. They are charged with a protective mission, not a law enforcement mission. I'm happy to talk further about the conditions, but I'd also like to talk about the second issue that the district court focused on, which was whether the Secretary of Defense committed a technical violation of the statute by not issuing the orders through the California governor. As you know, the district court found that the Secretary of Defense committed a procedural footfall by not issuing the orders through the California governor. But under the statute, the governor is merely a conduit, not a roadblock or a co-executive when the president decides that it's necessary to call up the guard. And in this case, the Secretary of Defense complied with Title 10 by issuing the orders through the governor via the adjutant general in California, who is the governor's chief of staff for these purposes and is delegated authority under California law to issue orders in the name of the governor. And I think the facts bear out that that was the right decision and the right procedure to follow, because the California adjutant general followed the order, forwarded the order to Governor Newsome, and the order was complied with. The whole point of this element of the statute
No, Brett,
is to
not
ensure that
yet.
there's a smooth handoff in the forces from the state.
Counsel, I'm going to ask a variant of this question to your friend when it's his turn. But do you read in the district court's order on this point a definitive statement of what it was that the secretary should have done to comply with this supposed requirement that obviously the district court found that sending it to the adjutant wasn't sufficient? But do you see, how does the United States interpret the order in terms of the specificity of this wasn't enough? How does the United States interpret the order of what would have been enough to comply with this?
I think it's unclear. It's unclear whether he meant that we should have copied Governor Newsome on the email. But he didn't say that. But he agreed with us that, disagreed with California, that the statute does not contain an approval requirement or a consultation requirement. But at the end of the day, I think that's what the district court imposed by saying, you can't issue it through the adjutant, you got to issue it through the Governor Newsome, in which case, what's the point, right? We're going to get to the same place because the governor has
the point is the law
under the second prong of the element sentence of the statute. He shall issue the orders, right? So even if we sent that email to Governor Newsome, we'd get to the same place. He would be required to send that order to the adjutant, and we'd be in the exact same place today.
I understand the United States' argument. There was no technical violation here, but even if there were a technical violation, the remedy imposed by the district court was all out of proportion to the supposed wrong.
Exactly, right? So at the district court hearing, we even asked the district court, if you think there's a technical violation of the statute, give us a chance to cure, right? We'll send the right email, whatever you think we need to do, we can do that. The district court did not give us that opportunity. Instead, the court issued an extraordinary injunction that basically vacated the president's decision, orders him to reverse his order and surrender control over a portion of the armed forces back to the California governor. That is an extraordinary order and remedy, wholly out of proportion. And under the Winter case, really the equities here are totally imbalanced for all the reasons we've explained in our declarations, given the mob violence and the threats that if this order goes into effect, there will be it will be putting lives at risk and federal property at risk as well.
The lies you tell.
So, counsel, you may not know the answer to this question, and it may not be in the record, but I'm asking about sort of current conditions. As the United States has pointed out, the proposed order that the state asked the district court to impose says in it that the order doesn't prohibit the force from providing indirect assistance to federal officials, protecting federal property, defending federal officials or employees from threatened physical harm, etc. Is right now, are the forces doing materially more than what was in that carve out that the state had proposed?
Yes, Your Honor. And I think that's clear from both the Nell declaration and the supplemental declaration from General Sherman that we submitted just with our reply brief. It explains not only are the guardsmen protecting the perimeter of the federal buildings, but also performing kind of an escort function when ICE agents go outside of the federal buildings. They are setting up a perimeter so those officers aren't assaulted by mobs when they're trying to enforce federal immigration laws. So even that proposed order would have been an extraordinary intrusion as well.
So even if that proposed order had been entered, the United States would, as of now, be doing things that would have been barred by that order?
Yes.
Okay, thank you.
In your view, is there any issue under the Posse Comitatus Act before us in the current posture of this case?
No, Your Honor. The district court ruled for us on that issue at this stage. In the TRO opinion, I don't understand the state to resurrect that argument for purposes of the stay. I'm happy to address it, but I mean, the point that we made in district court was that there is no violation of the Posse Comitatus Act. The orders are very clear that the guardsmen and the Marines are engaged in any protective mission that falls within the president's inherent power. They're not engaged in direct law enforcement. And I think the declarations from Nell and the other general that we submitted made clear that the guardsmen and the Marines are carrying out those orders faithfully, consistent with statute.
But your view is that there's no need even for us to say that much because the issue just isn't here.
That's correct.
Counsel, did you want to, and I know we've asked a lot.
So I think that this is going to be interesting because prior to this, when they argued this case originally in court, the Marine had not detained anyone prior to that. We know that over the weekend that the Marines did, in fact, detain a veteran and a U.S. citizen. So it'll be interesting because he said, we don't understand the, the governor to be bringing this issue back up, but I don't know that they are, or if that has changed since that occurred. So it'll be interesting to see what happens. Let's go.
Questions. Did you want to briefly address, or however long you want to address, the 10th Amendment issue?
Your Honor, I don't think there's much to say because I think it's completely derivative of the statutory question. I think the district court ultimately recognized that at the end of that portion of his opinion. I think the state recognizes that as well. If the president acted consistent with the statute here, then he's acting consistent with the Constitution because the militia clauses authorize Congress to delegate to the president the authority to call up the guard. If you permissibly called up the guard, of course, there's no 10th Amendment problem here.
Yeah, I read the district court's order as I believe you do, where the district court explicitly recognized that if the district court had gotten it wrong on the president's authority to call up the guard, that the 10th Amendment calculus would be materially different and might well weigh in the president's favor.
I think that's right. I mean, there's no 10th Amendment issue here if the president is acting consistent with the statute.
Right, and that's why you all want this
to answer any
argument.
Questions. If the court has no other questions,
After this,
to
Linda,
talk about kind of the situation on the ground in Los Angeles.
We're almost
today,
halfway through, so it's almost time for Newsome's attorney.
Other questions on those statutory issues?
I'm fine with your doing that, and I know Judge Miller and Judge Sung will ask questions if they feel it appropriate.
I don't think so, Brad. I think this
fine
judge
with
is
your
doing a
turning
great
to
job laying out exactly
Thank you,
the
Ron.
previous
I
decision.
just want to emphasize how crucial the Santa Cruz declarations are. The first one is at page 235 of the addendum.
This
The
was
second
live.
declaration
I'm
is
playing it back for folks
It
now.
explains the danger right now on the ground in Los Angeles.
Yes,
federal officers
Caitlin.
and property from the mob violence and disorder. Paragraph 7 of that declaration, the original one, explains how a violent mob tried to prevent ICE officers from conducting immigration enforcement operations in Los Angeles on Friday, June 6th, immediately prior to the president's invocation of this
No,
statute.
they didn't.
Paragraphs 9 through 17 then go on to explain an extremely dangerous situation involving violent and riotous demonstrators threatening to breach the federal building in Los Angeles that evening where ICE was detaining illegal aliens and federal officers were pinned down and severely outnumbered. It also explains how federal officers had to hold the building by themselves because it took over an hour and a half for local authorities to provide support and assistance to the federal officers. Paragraphs 18 through 20 describe what happened Saturday, June 7th, the day the president issued the order. 7 hours of constant fighting nonstop between ICE
Don't
agents
get
and a
angry.
violent
Remember, this is
crowd
just one
that
side of the
disrupted
argument,
an
folks.
immigration enforcement operation planned for that day. One officer was trapped inside her vehicle. Another shattered his or her wrist because of concrete blocks that are being thrown, mortar-style fireworks. Paragraph 33 of that declaration, I think, is essential here. It concludes, quote, "I believe the safety of local federal facilities and the safety of those conducting immigration enforcement operations in this area of responsibility requires additional manpower and resources." End quote.
Yeah, I know, Catherine.
That was a week ago. The supplemental declaration confirms the situation on the ground has not changed. There's still ongoing violence and an extraordinary need for the Guard in Los Angeles even today. Paragraph 4 explains that the federal building in Los Angeles, the one that had been breached the week before, has still been closed since June 9th. And again, concludes that the Guard is essential to protecting that property. Paragraph 6, I think, is also crucial. It explains that there are continuing violent protests at federal facilities throughout Los Angeles, including this past weekend. June 14th, there were 1,000 people assaulting law enforcement, a violent mob with rocks, bricks, fireworks, an extraordinary scene. That declaration concludes in paragraph 7 through 14 that the Guard is essential to continuing to safely enforce immigration laws and protecting federal buildings in Los Angeles. I just commend to the court, it is essential that this injunction be stayed, otherwise lives and property will be at risk. The court has no other question.
All right, do you want to reserve the remainder of your time?
Yes, thank you, Your Honor.
All right, we'll now hear for the attorney for the governor.
Here goes
of the state of
Newsome's
California.
attorney.
Good afternoon, Your Honors, and may it please the court, Samuel Harbert on behalf of the governor and state of California. Defendant's motion for a stay pending appeal should be denied. The framers of our Constitution gave Congress the authority to enact statutes governing when the president may call forth a state's National Guard into federal service. The only statute invoked here, 10 U.S.C. section 12406, requires that one of 3 factual predicates exist before that authority may be exercised.
Correct.
And requires that the federalization order be issued, quote, through the governor.
governors.
But on June 7th, for the first time in our nation's history, defendants federalized thousands of members of the state National Guard in circumstances where none of those factual predicates exist. And they circumvented the governor, who did not receive the order and who certainly did not issue it. For those reasons, the district court rightly held that the state is likely to prevail in showing that these actions exceeded the proper bounds of executive authority. In each of the equitable factors, counsels strongly against a stay pending appeal, which would allow defendants to prolong this unprecedented, unlawful executive action. To be sure, Los Angeles has seen certain episodes of unrest and even violence in recent days, including violence directed at state and local law enforcement officials. The state has strongly condemned these acts, and it has responded forcefully to them. And I would appreciate the opportunity at some point in my time this afternoon to respond to the suggestion from the other side. The state has been unwilling or unable to respond. A stay pending appeal would profoundly injure the state of California and our nation more generally. It would allow defendants to continue diverting thousands of guardsmen away from critical work at the state level, including wildfire prevention and drug interdiction. It would allow defendants to further escalate tensions and the risk of violence in the city of Los Angeles. And it would defy our constitutional traditions of preserving state sovereignty, of providing judicial review for the legality of executive action, of safeguarding our cherished rights to political protest, and of keeping the military.
Counsel, I want to start with one part of the district court's order. And as I read the district court's order on page 23 of the order, I believe it's denominated A283 in the record. I read the district court's order as saying that as long as the president can in some way or manner execute the laws of the United States,
yes,
that subsection 3 of 12406 isn't met.
correct.
That although there's no numbers in there, it suggests that if the president can 50% execute the laws, or 70% or 80%, or maybe even 15%, that this isn't met, and that what is required is that the president be wholly unable to execute the laws of the United States for him to be able to invoke the statute. So my first question is, am I reading the district court's order right? If I'm not, please tell me where I'm wrong. And if I am reading it right, does California agree with the district court's reading of the statute?
Your Honor, I'm not sure that the district court's analysis there needs to be read so expansively, and the state is certainly not asking the court to adopt that interpretation of prong 3. All we're asking the court to conclude, at least at this very early stage of the litigation, is at a bare minimum for prong 3 of the statute to exert any meaningful limit on executive authority in this area. It has to mean more than what defendants are suggesting. It has to at least mean that the president comes forward with some attempted justification, or at least an attempt to exhaust or at least contemplate more modest alternatives than immediately reaching the most.
But going back to a case that the United States cites, Martin v. Mott, I mean, one of the things the court said in that case is, we are all of opinion that the authority to decide whether the exigency has arisen belongs exclusively to the president, and that his decision is conclusive upon all other persons. And the court was including itself in the all other persons. Even if we were to agree with you that there is some limited role of judicial review, how can, with the facts here, and the language in Martin v. Mott, how can that test be met here by the state to justify an injunction against the president's actions?
Your Honor, I'd like to respond to Martin and then also explain why the state believes the modern language of section 12406 can't support the highly deferential, essentially unchecked view of authority under the third prong of the statute that the government is advancing here. So as to Martin, it was a very different case. It involved the determination of a foreign invasion. It's also decided many years ago, well before the emergence of modern political question doctrine cases like Zivotofsky, which say that when a court is addressing a core legal issue like interpretation of a statute as here, or the Constitution, that is a core exercise of judicial review. It's something that courts have a virtually unflagging obligation to do when they have jurisdiction. And I would add, as to Martin, Your Honor, the government has been making a very similar argument based on that case in the Alien Enemies Act context across the country. And as far as I'm aware, courts have uniformly rejected the government's very similar argument invoking Martin in that context, which involves the Alien Enemies Act, which implicates at least something closer to the types of foreign policy or national security considerations that have traditionally led courts not to deem cases justiciable.
So if we were to agree with you that there is some judicial review here,
yes,
how much discretion, if any, does California believe the president's judgment that this is necessary for him to comply with the take care clause and to take care that the laws be faithfully executed? How much discretion does he have, in California's view, under this statute in deciding when to federalize?
Your Honor, two answers. So I do think, looking at the text of section 12406, it's important to recognize that this statute illustrates Congress knows how to accord substantial discretion to the president when it wants to do so, because it does accord that type of discretion after a federalization decision has been properly made, consistent with the factual predicates in terms of the numbers of troops that the president deems appropriate to respond to the situation that justified federalization. You don't see that language in the factual predicates justifying the initial federalization decision. And it's an established feature of statutory interpretation that when Congress uses language in one part of a statute but omits it in another, courts presume that the omission is intentional.
Counsel,
does that mean we were, I'm sorry, go ahead. Sorry.
If we were writing on a blank slate, I would tend to agree with you. But the problem that I see for you is that Mott seemed to be dealing with very similar phrasing about whenever there is an invasion, then the president has discretion. And it seemingly rejected the exact argument that you're making, and seemed to broadly hold that even with that turn of phrase and that structure of the sentence, Congress was essentially giving the president the authority, the exclusive authority to determine whether the exigency existed. So how do you deal with that?
Your Honor, two very important distinctions with Mott. The first is one I mentioned a moment ago, which the determination about a foreign invasion implicates sensitive foreign policy.
Right, I understand the factual difference, but what I'm asking for you to address is the textual similarity.
The textual similarity, as we understand Martin, the approach that the court took there was not based on that particular language in the statute. It was based on the sensitive considerations involving foreign policy. And it was a very different context because there you had a plaintiff who was a member of the state militia, a low-ranking member of the military, objecting to a command coming from on high. And courts throughout our history have been reluctant to directly intervene in the chain of command in that manner. But in terms of, Judge Bennett, to get back to the second aspect of your question about whether we see room for any deference or discretion to the president here, we don't have a problem with according the president some level of appropriate deference based upon his experience implementing federal law. The problem as we see it is that there's really nothing to defer to here, because the president has not even attempted, defendants have made no attempt whatsoever to provide argument or evidence that they even contemplated more modest measures to the extreme response of calling in the National Guard and militarizing the situation.
Can I ask you to go back to the first part of this answer where you were responding to Judge Sung and for distinguishing Mott.
There was a question that I wanted to give everyone the answer to. The two male judges were appointed by Trump. The female judge, Judge Sung, was appointed by Biden. So that's the makeup of this court. I think it's also important to understand that there have been many Trump-appointed, Reagan-appointed judges that have ruled against the Trump administration because they also tend to be traditional conservatives who are constitutional lawyers. So don't let who appointed them be a point of concern for you. I would just take it that is what it is. And then let's just see the outcome of the case. You've got about another 20, 25 minutes of testimony, and then we can discuss. Okay. Yep, they do. And the judges are going to do that because, okay, so let me just tell you, the judges are going to interrupt and ask clarifying questions because they know exactly, Pravica, the Federalist Society ideology is different from MAGA, correct? But they're going to cut off because what they are taking point is the appellate court is looking at the judge's decision, not just the original arguments that they made before the first court. They are looking at the judge's decision to see what points in that decision may have been done in error or properly done, to see if they are going to uphold this decision, if they are going to modify this decision, or if they are going to overturn this decision. And so they are asking points that are areas of vulnerability in the decision that the previous judge made, that Judge Breyer made. So I understand that it's frustrating, but they're cutting off. They only gave it 90 minutes total with a 30-minute break for them to hear this case. So they need to cut to the places where they need answers, and they need to hear each position's argument or answer to those particular issues and those areas of vulnerability that need clarifying. Okay, so back to them asking the questions.
The ground that involves, a foreign invasion and a militia, a militiaman rather than somebody else challenging it. And, I agree those are both factual differences. But how do you deal with, Luther against Borden, not very long after Mott, seems to have read the opinion in a way that didn't attach significance to either of those distinctions. I mean, that Luther was not a foreign case, was not about somebody in the chain of command, and the court read it for this fairly broad preclusion of review of the president's decisions about when to call forth the militia. So what do we do with that?
Your Honor, I think that the court sitting today in 2025 should be quite cautious about relying on older authorities in this area, given the shifts over the years in the political question doctrine, justiciability doctrine, but also given the historical development of the strong norm in this country against military involvement in civilian affairs. So cases that predated the Posse Comitatus Act, for example, I think need to be looked at least with some caution before they're too readily or quickly applied to the circumstances of the sort we have here.
But those are maybe good arguments for the Supreme Court to reconsider those cases, but they've told us repeatedly that when there is a case that is directly applicable to an issue, even if we think it's been undercut by later developments and other areas of law or other statutes, as you mentioned, or other Supreme Court cases, we're supposed to follow the applicable case and leave it to them to overrule it. So I guess my question is, what can we as a Court of Appeals do with that argument?
Your Honor, I think for one thing, you can look to the other lower court cases around the country that have distinguished Martin in recent weeks and months in the Alien Enemies Act context as persuasive authority. I mean, I also think you can recognize that those older cases you're mentioning did not consider statutory language identical to the third prong of the statute here, or the government's extraordinary argument, which I think really does reduce down to the position that the president can federalize National Guard forces as soon as he makes a judgment that civilian federal law enforcement officials cannot do the job as they've been doing it in ideal circumstances or face any obstacles. Or to put it another way, as we understand the government's position on the third prong, they essentially have a binary view of the world, where there's world A, where federal officials like ICE agents are enforcing the law as they prefer. And then world B, they encounter any obstacle, and then the president can immediately reach for the most extreme possible measure on the table, which is federalizing National Guard troops. As we see it, there are gradations in between those two worlds. And at a minimum, prong 3 requires the president to make a showing that he's at least contemplated alternative, more modest measures before calling in the National Guard.
So counsel, even if I were to agree with you that the position advanced by the government that there's no review, we're wrong. Where in the jurisprudence of the Take Care Clause or the language of this statute is the president, with significant deference at least, required to have judicial review of whether he considered lesser measures? Where does that spring from, even if we were to agree with you that we have some ability to review the president's actions?
Your Honor, as we see it, it comes from the plain text of the third prong of section 12406, which of course is one of the laws that the president has a duty to take care is faithfully executed.
No,
it says unable, not just unable in general, but unable with the regular forces to execute the laws of the United States. And I point the court to opposing counsel's definition of regular forces offered before the district court. This is from the district court transcript, which I believe is available on the court's electronic document. It's that regular forces, quote, means everything other than the state National Guard. It could be local police, it could be federal marshals, it could be the Marines. Now, our position, which I think is really quite modest, is that given the enormous resources and personnel available to the federal government encompassed within that definition of regular forces, there at least needs to be some consideration of whether there are more modest measures than calling for the National Guard before taking that brave and extraordinary step. And in terms of highlighting why that step is so extraordinary, why it's been so rare in our history, I point the court to the amicus brief filed by high-ranking former military leaders, including former secretaries of the Navy and the Army, former four-star generals and admirals, who have explained the grave threat to the country's democratic traditions of licensing the government to adopt the expansive, near limitless reading of Section 12406 that it's articulated in this case. As that brief explains, this poses a risk, makes it all too easy for a president to call forth the National Guard to serve a domestic political policy agenda in a way that threatens to impugn, call into question the historic neutrality, impartiality, integrity of the military in the eyes of the public.
Counsel, that brief seemed to offer a lot of reasons why the president's decision was should have been counseled against, and that they wouldn't have agreed with it, that it's bad for policy, let's say. But I think it stopped short of saying the president couldn't do that, couldn't make that decision. Is there something in that brief that you think was saying the president was not actually able to make this decision?
Yes, Your Honor, in the sense that it highlights the grave consequences of an overly expansive interpretation of Section 12406, and that should inform the way that the court reads the statute. But that's not the only significant consequence the court should bear in mind. It should also consider the profound effect on our federal structure of government and the balance of power between states and the federal government. Our framers made the decision, it's reflected in the text of Article 1's militia clauses, to generally leave to state governments control over the militia, today the National Guard. What we see is that decision, the wisdom of that decision has endured over the years. And one of the most concrete ways to see that in this case is to look at the declarations filed in district court, which detail the critical functions performed by the California National Guard at the state level. That's central to our claim of irreparable harm in this case of leaving the state in effect. It's also central to the federalism concerns that we've raised that should animate the court's approach to construing Section 12406. I'd also, Your Honor, to the extent it's relevant to the court's determination of the third prong of Section 12406, I'd like to push back quite forcefully on opposing counsel's suggestion that state and local leaders, including law enforcement agents, are unwilling or unable to address the situation on the ground in Los Angeles. I think the factual record shows otherwise, including the Santa Cruz declaration that opposing counsel relied heavily on. We would encourage the court to rely on that declaration because I think it really highlights all of the efforts that state and local law enforcement have been making in recent days to respond to the situation. That includes making arrests. I think that the current number is around 1,000 arrests. There are thousands of state and local law enforcement officers that have been deployed. Local leaders have imposed a curfew in the affected areas between the hours of 8 p.m. and 6 a.m. There are other steps that have been taken as well, including using authority under state law to order unlawful assemblies and disperse crowds as necessary. State and local law enforcement officials are well trained in crowd control and management of civil unrest.
And counsel, I'm sure that all of your clients subscribe to what you put at page 1 of your opposition to the stay request. To be clear, the civil unrest in Los Angeles is a serious matter. Violence against government officers and property is unacceptable.
Absolutely, Your Honor. And the state and local leaders have roundly and repeatedly condemned this violence, which includes episodes, unrest not just directed against federal officials, but against state and local law enforcement officials as well. So it is a profound concern to the leaders of the state, but the state is dealing with it. Local law enforcement agencies are doing their job of dealing with it. And to get back to a suggestion that Judge Miller made to opposing counsel, which I agree with, that in terms of evaluating kind of the baseline when considering an invocation of prong 3 of the statute, it's worth stepping back and remembering that we're talking about federal law enforcement agencies that regularly encounter dangerous conditions in the field when doing their work. And so the question is the delta so significant? Are we in a world that's so different from normal conditions as to justify an extreme measure like militarizing the situation and bringing in the National Guard? We don't think that the federal government has even made the first step at seriously attempting to satisfy that standard. If I could, Your Honors, I'd like to turn to the through the governor requirements that the district court also applied. We acknowledge that there's some ambiguity in the meaning of this requirement, but we don't think it can credibly mean what the federal government suggests, because what that suggests is that while the Congress in 1908 added this language, it can be satisfied according to defendants by not involving the governor in any way, shape, or form. And then at the end of the process, when the decision is made, when the final document is issued, to just slap a label saying through the governor at the top of the document.
What is
go ahead, Judge Miller.
What is your understanding of how it's supposed to work? So if the president, I guess, with Secretary of Defense, writes up the order, sends it to the governor. If the governor then, looks at it, says, this is interesting, sticks it in his drawer, and goes out to lunch, what happens then?
Your Honor, I want to highlight just how far we are away from that.
No, don't answer the question.
There's no attempt to comply with it. Your Honor,
just hypothetically.
Our position is that the best understanding in light of our general expectation in our system that when Congress seeks to involve government officials,
that's the wrong answer.
To promote rather than undermining federalism and state sovereignty. So we think the best reading would be that the governor's consent is required, but we don't think the court needs to go nearly that far to agree with us that there was a violation here, because at a minimum, we think that issuance to the governor requires notifying the governor of the federalization decision and asking him to issue it, which would give the governor a chance to at least consult on the scope of the
So where does the statute say that issuing it through the governor requires either the governor's consent or requires consultation with the governor? Where in the text do you take that from?
Your Honor, we take it from the plain meaning of through the governor. So that's the first step. What does it mean to be issued through the governor? For the governor to issue it, we think at a minimum that means that the governor needs to be informed of it and given the chance to issue it. And here's why we think that the statute should be read to include at least a consultation opportunity, because the defendant's contrary view would pose very serious constitutional questions. So under their view, they can just do the whole process without consulting the governor at all and then slap his name at the top of the document at the end of the process. That risks blurring the lines of political accountability in much the same way as the commandeering laws that were struck down by the Supreme Court in cases like Prince and like Murphy. It essentially forces the governor to share in the political responsibility for.
So if we were to disagree with your reading and looked at this as a ministerial task that's in the statute, would there still have been more that
for those of you that are asking, the workshop is going to be rescheduled simply because we're still going through this hearing and awaiting the decision. At the time that I scheduled the workshop for today, all of this wasn't happening. So you will get an email notification for the rescheduling of the workshop. And I think the easiest thing to do is just set it from 1 week from today. So the same day of the week and the same time, but it will just be 1 week from today. So if you RSVP'd for the workshop that is supposed to occur at 6:30 today, that will happen 1 week from today at 6:30 p.m. Eastern Standard Time. You don't need to do anything different. I'll just change the date and you will get an email saying that so that we can finish listening here and then wait on the decision.
The United States would have been required to do, other than sending this to the adjutant, who is the governor's subordinate and issues all orders in the name of the governor. Would there have had to have been something directly to the governor's email or mailed? I'm not trying to be facetious here, but if we disagree with you about consultation and consent, was there anything more that needed to be done here as a technical matter in your view?
In our view, yes, Your Honor, to issue it through the governor, it needs to at least go to the governor. But if I could, I would like to take one more pass at persuading you that the federal government's interpretation just can't be right. As I understand it, they do present it as a purely ministerial requirement, essentially a routing requirement to ensure that there's not command confusion in the event that the state guard is transferred to federal authority. The reason we don't think that can be right is there are other federal statutes, most notably the Insurrection Act, which similarly allow the transfer of the National Guard to federal authority and pose the very same types of chain of command confusion that defendants have highlighted here. Those statutes do not include the same through the governor language. So Congress would have had, must have had something else in mind when it deliberately chose to add this language to the statute in 1908.
And if you wanted, I mean, it's a very roundabout way, I mean, of imposing a consultation requirement. It seems like on your reading, I mean, they should have said, you know, orders for these purposes shall be issued after consultation with the governor or something like that. This is a very indirect way of accomplishing that purpose, if that was the purpose, isn't it?
Not so sure it's indirect, Your Honor. I think when Congress imposed an issuance through the governor requirement, they were contemplating good faith on both sides and that there would be some level of coordination involved. And just one more point on this as evidence that our reading of the statute is correct. I'd actually point you to the president's memorandum on June 7th itself, which directed Secretary Hegseth to, quote, coordinate with the governors of the states. That suggests that even the president saw this statute as imposing some type of consultation or coordination
That's better.
requirement. Of course, Secretary Hegseth did not do so.
And what about, I mean, Judge Bennett alluded to this provision of state law a moment ago, but just as a general matter under principles of agency law, if you have to notify someone or get someone's consent or hear, you know, do something through someone, that means, you know, someone or that person's agent. And here, I guess the Military and Veterans Code, Section 163 of state law says that the Adjutant General can issue orders in the name of the governor. So it would seem like the state has made the Adjutant General effectively the substitute for the governor in this context. So why wasn't it enough that they sent it to that officer?
Your Honor, that's not our understanding of that provision of state law. As we understand it, the Adjutant General still has an obligation to communicate and coordinate with and take orders from the state's chief executive and the commander-in-chief of the armed forces under the California Constitution with respect to the National Guard. It's just after those decisions are made, the Adjutant General has authority to issue orders in the name of the governor. So we don't read it in the expansive way that our opponents do.
All of his duties under Section 163 are as prescribed by the governor, and he shall issue all orders in the name of the governor. I mean,
but he doesn't make up those orders
for a while. Yeah.
It has, Your Honor, and as I mentioned, we don't read it as the federal government does. I'd also point out, just because that state law may give the Adjutant General certain authorities, that doesn't mean that the president has certain authority to issue orders through the name of the governor under federal law. And we know from the plain text, Section 12406, that Congress knew how to allow orders to be issued through a commanding officer, because that is the process prescribed with respect to the National Guard of the District of Columbia.
But that prescription is federal law.
It is, Your Honor.
I mean, the DC prescription, I take the reason they mentioned that there is because that is a matter of federal law over which the Congress has control.
My point is simply that the text illustrates that Congress knew how to allow an order to be issued through a commanding officer instead of a chief executive, and it didn't do that with respect to the governors of the 50 sovereign states.
Council, I want to go back to the what you're arguing in terms of the conditions necessary for the president to exercise its calling forth power as delegated by the statute. I hear you arguing that the exigency required under subsection 3, essentially the inability to execute the laws with the regular forces, wasn't met. I don't hear you arguing that the president cannot rely on that subsection based on anything it said in the executive order, or that it wasn't properly invoked or relied on. I hear you arguing that we can and should consider the evidence put forth before the district court, not that we would be limited to what's in the executive order. So are you conceding those points?
If I understand the question, I certainly acknowledge that, yes, the district court should have been looking at the evidence put forward by the federal government to try to satisfy the factual predicates required under section 12406. And as the district court rightly concluded, the federal government had failed to provide argument or evidence that would even really make a serious attempt at satisfying that predicate, because it didn't even suggest that it contemplated more modest measures than calling in the National Guard.
I'll try to clarify my question. You are not arguing that we would be limited only to what was stated in the executive order to determine whether the factual basis is there. Is that correct?
I see, that's correct.
And you're not arguing that the executive order failed to rely on subsection 3 or invoke subsection 3. Is that correct?
That's not an argument that we've made, at least at this preliminary stage of the litigation. That's right. Although I do think it's notable that the federal government has principally relied in its papers and in the executive order on prong 2, which I do think suggests that they understood, they didn't make a serious effort to show evidence or argument as to prong 3.
Okay.
Your Honors, with permission of the court, I know that I've gone past my time. I would like to very briefly address irreparable harm.
That's fine, counsel. Please do so.
Thank you, Your Honor. We would ask the court to reject the government's motion for a stay pending appeal, because every day that the stay remains in effect, it causes these 2 principal forms of irreparable harm that I'd like to highlight. One is the concrete harm to important state functions that are not happening because of the diversion of now fully 1/3 of California's National Guard troops that are available to the president's unlawful mission on the streets of Los Angeles. That's causing harm in terms of not having troops on the ground ready to respond to emergencies, especially wildfires, which is especially problematic as we enter the peak of wildfire season, which experts believe is likely to be especially harmful and severe this year. The EC declarations, again, just briefly, Your Honors, detail the many important functions beyond wildfire prevention, emergency response, drug interdiction performed by our National Guard units when they're not federalized. Beyond that, every day that this order remains in effect, it is causing harm to our nation's broader democratic tradition of separation of the military from civilian affairs. And that is not just a problem for the 60-day presumptive deployment here, which could be extended further by Secretary Hegseth. It's a problem because it sets a precedent for this president and future presidents to take similar actions going forward. And just in closing, Your Honors, in considering the legality of the president's actions and the request for a stay, it's important to bear in mind the sheer scope of the president's order here. We've been focused today on the conditions in Los Angeles, but the order is not limited. The president's order is not limited to Los Angeles or even California. There's no limit in terms of geography whatsoever. It's not limited in the number of troops that can be called up. It's not limited in the duration that those troops can be called up for. And there is no real limit imposed on the scope of the mission. It's not limited to assistance with ICE enforcement. It also allows for protection of, quote, other US government personnel who are performing federal functions. That's essentially anything the federal government is doing. That is staggeringly broad in scope. In the state's view, it is plainly unlawful, inconsistent with our nation's traditions. We would respectfully ask the court to deny the government's extraordinary motion for a stay pending appeal.
All right, thank you. Mr. Shumate,
Here
you
goes
have,
the rebuttal.
time left.
Relax, here's the rebuttal.
Thank you, Your Honor. If I may, I'd like to make 3 quick points in rebuttal. And I want to start first with the Martin case, which there's some discussion of that case. The point I want to make is that that decision is both controlling and it remains good law. It's controlling because the statute in that case is very similarly structured to the statute at issue here. The Act of 1795, again, started with a wherever clause, and it had one condition, invasion. And if that condition was met, the president could call forth the militia. Here, the statute also starts with a whenever clause. It also includes the invasion problem, but it also has 2 additional elements. And it concludes with a delegation to the president that he may call forth the guard if in his judgment it's necessary.
No, but they're 2 different circumstances.
Deciding a reviewability question, you look at the language of the statute, not factual distinctions on the ground. Yes, in that case, it was an invasion, it was a foreign policy matter, but this statute also, that's before you here, Title 10, also invokes foreign affairs powers and the president's domestic powers as well. And it's also remains good law, right? We cited the Dalton case, which was a 1990s decision that invoked the same principle, where a statute is drawn in a way that delegates broad discretion to the president.
They didn't argue that there was an invasion. Give me a second.
The president's judgment. Courts don't review the president's judgment. And that's what we have here. And in that case, it was a domestic matter, not a foreign policy matter. So Martin would not be just limited to foreign policy matters. The second point I wanted to make was the easiest path to a decision here is on the third problem. The president made a determination that he is unable, based on with the regular forces, to execute the laws of the United States. The record certainly bears that out, not only in his proclamation, but also in the declarations. Make clear that the plaintiffs have conceded there is civil unrest in Los Angeles, but not just ordinary civil unrest. Civil unrest is targeting federal law enforcement officials and designed and aimed to prevent them from carrying out their duties. The court should at least defer to the president's judgment under prong 3. And then finally, on the through language, I think the plaintiffs have an extraordinarily dangerous interpretation of that statute. Under their reading of the statute, Governor Newsome could pocket veto the president's orders, not convey them, and wait for somebody to come down to Sacramento, consult with him before he issues that order.
No.
That is not what the statute says. The statute says through the governor, it doesn't say by the governor. We've cited other statutes that are similar, that contain the consultation language. This statute does not contain that language. In sum, Your Honors, we would ask you to grant our motion for a stay pending appeal. If you deny our stay pending appeal, we would ask the court to give us an opportunity to seek emergency relief from the Supreme Court. Thank you.
All right, we thank all counsel for their helpful arguments, especially on an expedited basis. We thank counsel for appearing remotely. I would also simply note that the panel is cognizant of the fact that you have another hearing set on Friday before Judge Breyer. And again, thank you. And with that, the court is adjourned.
All right. So a couple of things that I want to talk about. Okay. I just now got water, Jen Penn, because the answer to that question is no. I'm not hydrating. I've been holding my breath for the last little bit. Okay, so first, let me just say this. Don't read a lot into the questioning of the judges. That is going to be what they do, and to see what the arguments are. Don't get upset about who is appointed and yeah, it's just water. I promise. But don't read too much into the wording of the questions. Don't read too much into who appointed these particular judges, because what we have seen throughout this entire journey in the couple of hundred of court cases that have decided against the Trump administration is it doesn't matter who appoints these judges, right? Many of them have just, gone right along and done what they needed to do. So I think that people need to remember, right? He did keep saying contemplating any other remedy, right? And so that's I agree, civic engagement. So civic engagement is talking about, let me just read this comment from civic engagement over on YouTube. Okay, so listen. Civic engagement says good. He kept saying contemplating any other remedy. But I wanted him to say he did not attempt another remedy. He didn't order additional ICE agents, other federal agents to the area. He immediately went around the governor of the state that explicitly said he had it under control to commandeer state National Guard troops. I agree with you 100%. So things that I think, and I hope that Peter does join here, because Peter is part of the team that put this argument together, right? And so I think that one of the things that I think would have been helpful, right, is so the claim was made that things happened on the 6th and the 7th, right? I have continuously pointed out that the Los Angeles Police Department said that June 7th ended without incident, right? I think what would have been great was to have the pre-National Guard numbers for incidents and the post-National Guard numbers. So, for example, if violence did escalate after the federalization of the National Guard troops and they were brought into Los Angeles, right? If that did escalate things, I would have wanted to have pre and post numbers to present to the court, right? Because then you would be able to see that exactly what Governor Newsome said was going to happen did. And that, in spite of being advised by the governor, right, not to do that, and that it would absolutely escalate things, rather than considering that, right, and considering state sovereignty and what the governor of that state is saying, the president went ahead and sent those National Guard anyway. So I think that would have been helpful. I also think exactly what civic engagement said, right? Not seeking any other remedy, right? Not seeking, more ICE troops, not seeking more LAPD or marshals or any of those other things. They are going to, so Camille, you know me better than this. I do not speculate as to the decision that the court is going to make. And the reason I don't do that is because my name is not Miss Cleo. I am not a psychic. I do not see into the future. I don't know what those 3 judges are going to do. What I am going to do is talk about the parts of the case, and to talk about the parts of the actual arguments that I think could be potential issues. And you are welcome to join that conversation with me, right? Right. Automatically going to the most extreme escalation. And I believe the reason for the accelerated escalation on the behalf of the government was to get to the end, which would be unreviewable presidential power when it comes to state National Guards, right? And so I think that is a powerful argument that Governor Newsom's attorney did make, and I think that here's Peter. I'm glad you're here, friend, because I was just talking about you. Peter, can you hear me?
Oh, yes, I can. Yes.
I was just saying I was hopeful that you were going to come. So we just finished listening to the entire arguments from today, right? And we're still waiting on a decision, right?
We are.
Okay. So things that I would like to know, because let me just preface this by saying I am not a lawyer, right? But one of the things that I thought would have...
Miss Cleo? I thought you said you were Miss Cleo.
I said I wasn't Miss Cleo, because somebody said, what do you think the court is going to do? And I said, I am not Miss Cleo. I don't know what them 3 people going to do. And what I've learned is,
I'm playing with you, Daddy. I'm sorry.
Yeah, you just don't know what them people are going to do. But one of the things that I think would have been helpful for the state's case is to be able to lay out to the court those 2 points. One, that civic engagement made that I agree with is that there weren't any other remedies that were attempted. There was no extra ICE agents called in, U.S. Marshals called in, any other. It was immediately to the National Guard, right? That's number one. Number two, I would have loved to see, because LAPD, I know you know this, but LAPD on June 7th, the same day that this presidential memorandum was done, the LAPD issued a public statement saying in that statement that the day ended, quote, without incident, and that they were thanking the coordinators and the organizers and everyone for exercising their First Amendment rights responsibly. I'm wondering why we didn't make that argument to the court that on the day that the president federalized the National Guard, local law enforcement absolutely said that everything was going well, that there were no violent incidents on that day, and then have the numbers for the number of violent incidents that have occurred since the National Guard arrived, because Newsome said that's what was going to happen. It was going to escalate it. So why didn't the state make that argument?
That's an interesting point, because that was one of the things that has made me hoarse all weekend, is that I've been arguing this point with the others that were arguing for the team on behalf of us. And I can tell you right now, that was one of the things that we have been drilling. And all of a sudden, one of the partners, I'm not going to name him, but he got in the way and he said, no, that's a losing argument. But you know what? That's not a losing argument. That would have been the one, I think, it would have been something that the government should have been pressed on, because it was the overreach of the exercise of power. And not only that, my whole thing as a constitutional lawyer is to go into the constitutional arguments, and the 10th Amendment was not touched. If it was touched, it was touched very thinly. It was just essentially ignored, because the 10th Amendment is very clear. Rights that are not given to the federal government are given to the state. That's essentially what it means.
Yes.
And so the states have every right to control everything that's going on in their jurisdiction. The federal government does not need to step in. And for the federal government to have stepped in the way that they did, and the way that they have decided that, Los Angeles can't handle themselves because, they have, they're lawless. They're killing everybody there. They're using everything, which was a bunch of bullshit, and you know it.
Yes. So let me just say this to the person in the comments who said that they didn't use the statement because the police chief turned around and contradicted it. The police chief did not say that until on the 8th, after the federalization had already happened. So I need for people to understand that it wasn't contradicted until after that, when things were already beginning to escalate from the Trump administration. And so I think that people need to really understand what I thought were the strongest points, right, to be argued is, number one, the immediate escalation going straight to the National Guard with no other remedies. I also think that the attorney that was arguing it missed an opportunity, because what they said is, okay, what does through the governor mean, right? Issuing orders through the governor, what does that mean? And I don't think that we ever got a really clear answer. And so I'm wondering, was there any effort to look at other court cases in which, the law states that something has to happen through an individual versus around it, and then being able to argue it from that perspective? Because I would like to see, what are the court cases that have been decided around similar language regarding orders being given?
Yes, Danny, and that's a significant point you make, because that is one of the issues that we were arguing ad nauseum. In fact, that argument was made during the hearing at noon today, and they used the Martin case. Remember that in the Ninth Circuit, you can address cases or you can use cases that are within the Ninth Circuit Court of Appeals, which is like 9 states that we can look at right now. And so they used, and it was defined that when you say that you're going through the governor, it literally means you need to pick up the effing phone and call him up or text him or something and make him known that that's being that a power is about to be used, and you got to get his blessing. it's not enough. It's not enough for you to say that, oh, we decide ab initio, which means from the very beginning that we're going to run the show, and that's the problem with the usurping of the federal government. That argument was made today, Danny. It really was.
I know that it was made, but what I'm saying is when he was asked, he said, okay, so let's just say that I agree with you that that the orders did have to go through the governor. What would have fulfilled that requirement? So that's what those judges asked him today. They said, what would have fulfilled that? Did he simply need to be copied on the email, right? Because it doesn't say that the governor needs to approve or co-sign it. It just said that it needs to be gone through him. And so when they asked that question, he did not have a definitive answer. And I didn't like him saying at this early stage, because he's already saying we ain't going to argue everything right now because we know it's going to go to the Supreme Court. And I hear you. However, what would be your answer to that? Is okay, what would that have meant going through the governor? Do you all believe that the interpretation of through the governor is not just consultation, not just awareness, not just direct communication, but approval by the governor?
That's exactly what it means. Plain and simple.
So this is my thing. He, instead of just kind of him hawing it around it would have been great. So what do you remember off the top of your head, what court cases were part of the decision saying that? Because he did say it, Veronica. He did say that he believed it, but then he said, "But we're not saying that that the court needs to go that far." Da 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 da. But
No, stop it.
yeah, hold on, civic engagement. I can. So this is the case. I'm wondering why he didn't cite those other cases as the support for that particular argument that it required the governor's approval.
You know, Danny, I have to be very political about this.
I know.
Because we're going back to court in front of Breyer on Friday.
I do know that.
It's continuing. This is an issue that is continuing. So I would love to say something more.
But don't.
But if I do, my ass will be beat. I'll get the beat down that I don't want.
I got it.
Not good. I'm a partner in my law firm. I don't need a beat down from my partners, and I certainly don't need a beat down from anyone who's on our team. Who are seasoned attorneys. So I get what you're saying, and I hear, and you're heard. But these arguments are going to be raised again on
Friday.
Yeah,
right. So
it's unfortunate that this whole thing was remote. I went up to San Francisco this morning thinking, oh, we're going to go before the Ninth Circuit Court, and we were just put into a fucking conference room, and then I'm watching everybody on a monitor. I'm saying, what the hell is going on here?
Yeah.
I normally that does not happen. And what I was told by the court clerk was that it's happening because it's an expedited basis, and so they need it, to hold on a second.
I know you got them dogs. I know.
And you know what I need? Hold on. And they understand one language very clearly. There, that takes that. Hey! There, that's the end of that. Sorry. But sometimes, they need a beat down, just like kids do. And so I'll give them the beat down later, not now. But I understand the frustration that's going on and the confusion, to be honest with you. It's not just frustration, it's confusion. It's not, and because they're not being very clear about what's going on. We don't know. We don't know what the hell those three appellate judges are saying. In fact, to be honest with you, I'm a little unsettled. I think they're just going to agree with the Trump administration, to be honest with you. And that would mean another fight. We're going to have to go to the United States Supreme Court. And that's when everybody has to back down, because the senior person at the Supreme Court who argues it is me. And then they're going to hear a voice. Now, unfortunately, that also means that two of the justices that I would depend on for part of this would have to recuse themselves, because every time that Sotomayor and Cagle see me, they said, "Oh, we got to go. We got to sit down and have popcorn and just watch it all happen."
Okay, so somebody is asking you to cite the difference between using the National Guard in this particular instance versus when it was called in for the integration of schools and Ruby Bridges.
That is a very good distinction. the distinction is very clear. Well, for me, it's very clear. That's not me making that.
No, that's me. That's me.
Okay. Let me just say that the distinction is very clear. In that regard, the state was unable to really control what was taking place at that point. And there was so much chaos and so much destruction already taking place. People were being killed. Things were being burned. I mean, whatever you needed to do to bring control, that's one thing.
Yeah.
And that the federalization of the National Guard took place at that point. So yes, that was a legitimate purpose, and then it got under control to the extent that you want to call it control.
No, not so loud.
But
right.
Here in California, that was never the case. There's a distinction. And the commander-in-chief of the National Guard is never the president. The commander-in-chief is the governor. And that is why you need to go through the governor to receive that kind of information. There's the distinction right there. And we never asked for it. It was never requested. You know why? We didn't need it. And Los Angeles police were very clear. We're not going to step in for the minute, but we'll step in if we have to.
Absolutely, they were. And so my whole point was, when I looked at the fact that the presidential memorandum, and I'm not an attorney, I don't even play one on TV, I don't play one on TikTok, right? But when I looked at it, and the fact that the presidential memorandum and that statement from the LAPD, and LAPD statement came at the end of the day, because they said the day ended without incident, right? So the fact that the presidential memorandum was given before the LAPD statement, and the LAPD statement clearly said everything was fine, right? I thought that was a strong argument to present before the court. And being able to say, okay, so because did you hear them? They cited something that supposedly happened on the 6th. Do you guys know what they're referring to?
Absolutely not. That came to us as a surprise as well.
Okay, so that's what I would want to see. So I would want to go back, and I would want to look at any incidents that occurred on the 5th, 6th, and 7th, which, by the way, I don't know if you heard him say this, but Tom Homan made the statement, girls, not so loud. You're literally sitting right next to each other, and you are talking louder than me. Sweet baby Jesus. Okay, so Tom Homan in an interview, I can look it up and tell you which one, but Tom Homan made the comment that he has been in LA since that Wednesday oh gosh, what word did he use? Oh, in anticipation for an operation. That's what he said. He said he had been in LA since Wednesday for an operation, and I'm interested. What operation was that? Right, because he's there on the 5th.
There were going to be raids, and they were down. They have downplayed that now, but there were going to be all these planned raids that were going to go on to all these businesses here in Los Angeles, and that was something that we knew. In fact, everyone in LA kind of knew about it, but didn't. So if you were in the know, you knew. And so we were just watching, and I hate to say that because I can watch and see how things will happen. I can get in contact with my clients and say, wait a minute, we have things that are going on. And that Home Depot raid on the 6th really was the tinder block. That was the one that started the huge blaze, as I call it, with ICE and everyone else. And that's not too far from where I live, and that's certainly because I live in downtown Los Angeles, and that was a touching point. I mean, that was the biggest issue. And then when Churla, it's an organization, called me up and said, and then the ACLU called me up and said, wait a minute, what can we do? What can we do? Can we help these people? I said, I'm gonna get in the fucking car right now. Hold on a minute. I'm going there. And by that time, they had already picked up a whole bunch of people.
And so this is my thing. So what I would be arguing, right, is that on the 5th and the 6th, right, when they were in Home Depot and the other places and conducting their raids, they were very successful to do that, right? I would be looking at the number of people that they picked up on the 7th. And because that is a demonstration. When they say, oh, well, violence kicked off on the 6th. Well, if you were able to successfully conduct raids and round up hundreds of people, then obviously you were able to execute the laws of the government, were you not? So in what way were you prohibited from doing that on the 6th or on the 7th, right? Because if you were able to round up and this many of people, then obviously you were able to execute the laws of the government. And so that would be number one. I would be looking at how many people, girls, how many people did they round up on the 5th? These are my grandchildren.
So it's your day to watch them. I get it.
I watch them a lot because corporations don't like to pay a living wage, and my daughter works 2 jobs, and right now she's sick also. So I have them a lot. But this is the 2 girls, and listen, these children are multiracial. So they are white, they are black, they are Latina, they are everything. So everything is loud and very passionate.
Of course it is. Of course it is. And I learned that the hard way. I have 2 sets of triplet girls, and I learned that the hard way. In 1 year, I had 6 girls, so I know what it's like. And then as they grew up as teenagers, they love to jump and scream and do all kinds of stupid shit, and I had to watch it. And so let me tell you something. As a dad, because I ended up being a single dad because I had to get rid of my wife, who was a fucking bitch from Mississippi. But anyway, that said, I'm sorry. I raised these kids on my own. So let me tell you
all 10 of them.
All 10. And I have no regrets. But I also know as a protective dad, these girls did not leave my sight unless I knew who they were going with and
absolutely
whatever was going on. So I don't mean to distract from the conversation, but as a parent, from one parent to another, we know we gotta watch.
Yeah.
Unfortunately, there's a double standard, and that's how it is in my house.
Listen, they are literally sitting this far apart. At the kitchen counter.
They gotta scream and hit each other.
Yes. Why y'all talking so loud? You are literally sitting right beside each other. But so I would be interested in being able to see the number of arrests or detainments that happened on the 5th, 6th, and 7th. I would be looking at the number of violent incidents that happens, quote unquote, on those same days versus how they happened on the 8th and every day since then. Since the Trump administration went ahead and federalized the National Guard as an argument.
The administration is going to take credit for the reduction in the number of arrests that have taken place, not the number of deportations, because that went up, but the number of arrests they're going to take credit for by claiming, among other things, it was because they sent in.
No, but I'm saying the number of violent incidents. So I would be looking not just the number of arrests, but
Danny, that is all public information.
Yes, and so this is what I'm saying. I would be looking at not only the number of arrests, but the charges, right? So if the number of arrests increased, but there was a significant increase in the percentage of arrests that were violent versus the percentage of arrests that weren't prior to the National Guard being federalized compared to after, that would be my argument. Because obviously, if you introduce more policing, you're going to have more arrests, period. We know that. We see it in Black communities all the time, right? But the difference would be what percentage of those arrests were actually violent, related due to violence versus not. And how much did that change after Trump federalized the National Guard?
You know what, Danny, you just, you make a significant point, and that's a point that needs to be drilled down. So when we go back to prior, I'm going to make sure that your voice is heard. I'm going to make sure that what you just said makes such a significant point. I mean, I'm going to say, you know what? Get the fuck out of here. Everybody just listen up. I want Danny's voice. I'm going to say it just like that. I want Danny's voice to be heard. And they're going to ask me, well, who's Danny? Well, guess who? Guess who Danny is? Danny is a part of my posse. She is a part of my campaign. Because you know what, Danny, I'm not going to take no for an answer. And I'm going to keep asking you, are you going to join the damn campaign or not? So whatever, I'm just going to keep persisting until
I heard you. But I love the fact that you will take those points, because I've been sitting over here since day one, and everybody will go like, "What's your background? Are you a lawyer?" And I'm not, right? But I just read, and my mother.
You don't have to be a lawyer as long as you're informed, and that's the important thing. Is that sometimes people just run their mouths about shit they don't know.
Yeah.
And the truth of the matter is, you better educate yourself. And if you feel like you need to learn something, go and learn it. There's no harm. And guess what? Google is free. Last I checked, Google is
100%.
free. Get on there and do the research. I mean, I use Google, but I use the AI portion of it now.
I do not, and you know better than that, because AI be getting shit wrong sometimes.
It does. But sometimes I need a little like, what what's going on? What is the other side thinking? And that's what I use it for.
Yeah, 100%. So this is one of the things that that I say about, kind of looking at information. Somebody earlier said this mincing of words is nerve-wracking, right? That's what this person was saying when we were watching the arguments. But people don't understand that is exactly what law is. Law is the interpretation and the drilling down of specific legal meanings of words. And that's exactly what it is. Okay, so I'm laughing right now. So Trump says he's going to extend TikTok another 90 days. Listen, y'all, TikTok ain't going no damn where. And the reason why is because 60% of TikTok is now not owned by ByteDance. It is owned by different companies in the United States, the largest one being BlackRock. So now that BlackRock has a significant share of TikTok, it ain't never going nowhere because corruption is what corruption is. So just so y'all know, he ain't doing shit special, not a damn thing. It is because people in this country are making hella money. And now ByteDance only retains 20% of the company.
Yeah, but unfortunately, ByteDance also holds on to that valuable algorithm, and that's the issue.
Yeah, but this is my thing, right? So listen, if you really want me to be honest with you, I would much rather have China with my data than ByteDance and Trump, than BlackRock and Trump, because for me, so this is the way I look at it: is every projection that the Trump administration and the Trump campaign makes for me is a confession. Right. So when they say that they are stealing data and that they are doing whatever, that is what Peter Thiel and Donald Trump and Elon Musk are doing. Right. Every time they make an accusation, just like the representative in South Carolina, May. Right. All of them talking about how the left is trying to do this to children and the left is. And meanwhile, his ass has got a Joe Biden name on an account and he's doing child porn. Right. By the way, then they found out he traveled to Colombia, Cambodia, somewhere, and his ass was having schmecks with young girls. And this is the same guy who was busy. So I just need for y'all to understand. When they talk about, when Donald Trump says there's an enemy within, there is, and it's them. It's them. It's 100%. So no, I'm not. It's the United States government right now that is the issue. But yeah, I would love to see those numbers. And now I'm just circling right back around. That's my ADHD. I'm just circling right back around to the court case.
You are circling in the right direction. Go on.
Yep. And so that's the part that I would love to see. I love it. They just lost again in court. The Trump administration just lost again in court about the passports. And the sex identification on the passports, they just lost. So hold on one second.
Doesn't surprise me, but that sounds like something that would come out of California, or at least here in the West.
So here it goes again. So U.S. judge blocks the Trump passport policy targeting transgender people. Girls, something was going to unalive them in the game. So he lost today in court. Love that for him. But anyway, okay. So circling back around, the things that I would love to see argued would be the number of arrests prior to the federalization of the National Guard and the percentage of those arrests that are due to violence, and what percentage of that was prior to the federalization of the National Guard, what was the percentage after they were federalized, overall across the board. Trump lost today when it comes to passports. Today, we will get a decision from the appellate court from the Ninth Circuit, but they're also going to be in front of Breyer again on this Friday, y'all. So this is not something that is going to be over and done with today. So what you got to do is be just like this. Don't let a case get you super up here or super down here, because you'll be sick from the roller coaster ride, right? So you just got to take it all in stride and ride the waves, because that's what we're on.
And there's a lot of moving parts, and unfortunately, this is one of those moving parts that I have to admit, we may end up at the United States Supreme Court, which is great because that's my playground. And I love arguing in front of that fucking idiot, Thomas. Oh my God, he's a
he is not a smart man. And I'll tell you who is interesting for me, because I don't know if you all know this or not. And we all know that Amy Coney Barrett has given us surprising decisions. What I don't know that people know is that since her appointment under the Trump administration, she has gone.
I'm sorry,
Justice Amy Coney Barrett. Girls. Shh. So since that, hey girls, I need you to go play on the couch. Y'all sitting too close to me. Go play together on the couch. Jesus. I don't know what is trying to unalive them in this game, but they screaming because it's chasing them.
I used to use a squirt gun.
Okay, so check this out. So we all know that she has given us surprising decisions against the Trump administration. However, I don't know that people actually know this part. So she has gone from when she was first appointed, she was agreeing with the conservative members of the court 92% of the time, right? That has now decreased down to 84% of the time. And you might not think that's significant. However, she used to not agree. She used to agree with the Democrats on the Supreme Court only 60-something% of the time. And that percentage is up to 91 or 92%. So she is now agreeing with the Democrats on a percentage that she used to with conservatives. So that is important as we look at a lot of these cases that were going up, that are going to go up before the Supreme Court. Because I told you what my theory is. I think that many members, federal judges, especially those appointed by Republicans, I think many of them, they're okay with racism, they're okay with sexism, they're okay with transphobia and homophobia, right? But what they're not okay with is violating that damn Constitution. Like they have a line that, so MAGA ideology, like we said before, is not the same as the Federalist Society ideology. They are two different groups of people.
That's absolutely true, and unfortunately for the Republicans, and this happens a lot. In fact, it's happening all the time. Is that they fail to recognize the oath that we all took when we got our professional licenses, even as attorneys and judges and whatnot. We all take an oath to protect and defend the Constitution, the U.S. Constitution, not to pervert it, not to change it into something else, but to protect it.
100%.
And that is the problem that is going on right now.
Yeah, 100%. And I think that's why I think you saw, because, I'm an Army veteran. That's why I think you saw.
And I am too. So.
Yep, I do know that. I think you said
I'm a
Lieutenant Colonel. Yep.
Lieutenant Colonel,
I remember.
yes.
I remember. He got light wings, y'all. He got light wings. Right? That's what we used to call lieutenant colonels, right? Because full bird's a little bit different, yes. Right? But yeah, so, I think that is why we saw the performance of the military the way that we did on Saturday, right? I believe that because we know how to show up squared away, right? We know how to be aligned and in formation and on time, but they weren't. And I think that there's a reason why that was. That's just my own feeling. When I look at how they showed up on Saturday, I don't think they wanted to be there. I think people were.
No, they didn't. And to be honest with you, I was in my uniform, full uniform. It didn't fit right, but fuck it, I went anyway. I squished my body in it, and that was the end of that. But I went.
Yeah.
And I watched that display, and let me tell you something. It was pathetic. It was disgusting, to be honest with you. How we spent so much money.
Yeah, $40 million.
How all that money was misspent when quite frankly, that 40 million here in Los Angeles would have gone a long way with putting people out of homelessness and putting them into housing and feeding children and schooling children. All of that.
Well, you know what I said? Here's my thing. If it was supposed to be about celebrating the 250th anniversary of the Army, right? Then you could have used that $40 million, right, to give military and veterans a pay raise. You could have used that $40 million to hire some more CMP doctors and some more doctors for VA hospitals. You could have used that $40 million to do a lot of things that would have actually been helpful for people who are serving and who have served, if you really wanted to honor us, right? But it wasn't about honoring the United States military. It wasn't about that. 100%. So
no, it was all about him and then his sour face. If anyone has seen any footage, he's sitting there either falling asleep or with a sour face.
Yeah. So Yari, we postponed it for 1 week from today because we were listening to the arguments before the Ninth Circuit, and then Peter joined the panel, and so we're discussing the argument. So the workshop will be 1 week from today. You will get an updated email. So don't fret. There's nothing new that you need to do. Just don't worry about it. It'll be just fine. Okay. So Peter, I offer free workshops to the public. And so some of that is where I talk about ways to have informative and productive conversations with people of opposing views. Sometimes I do it around specific issues like immigration or Medicaid or healthcare, and just giving people accurate information so that they can conduct themselves. I even did one on I call it my Get Into Good Trouble workshop. And it's teaching people how to use FOIA requests. It's teaching people how to write their legislators effectively and actually get responses. When do you need to do a petition? Is it better to do it electronic or in person or on paper, and all of those different things? And so, yeah, so
Jenny, that is commendable. Get out of here, girl. I had no idea you had that going on for you. And let me tell you something. That is something to be commended. I'm going to make sure. Hold on a second. I'm going to make sure that I get a whole bunch of followers to follow you on that, because that is really super important. And here's the other thing. And I will throw myself out there because this is how I am. If you ever need anyone to step up and say, you want free legal advice, ask any question at all, guess what? I'll be the person who will step in and say, yes, you could do this. Yes, you could do that. You want to hear this? Let's go.
Yeah.
And I will be glad to accept any kind of request.
Oh, I love that. I will,
whether it be criminal or civil or immigration. I've been in this business now for almost 40 years, thankfully. And so it's been very good to me, and I need to give back, which is the reason why I'm running for Congress, because I'm done with the law business. I'm done with these motherfuckers. I'm sick and tired of listening to all the bullshit. I made my money. Guess what? I paid that money to my kids' education, and that's the end of that. That makes me happy. They're done. They don't have any bills, nothing. And so I now need to go do something more for me. And that is about helping people. And that's what I'm all about. Danny, if you want my help, you just ask for it.
I'll shoot you a message and give you my contact info. If you, so like when you go to my TikTok profile, this is for everybody that's listening. And I can just show you what it looks like. I showed folks earlier. So if you go to my TikTok profile, folks on here already know, but I will show you very quickly so that people know, because I believe that one of the issues that we have right now is a lack of accurate information, right? So let me share this with the folks that are on YouTube and on Facebook. All right. So when we go to my link tree, so this is my link tree, folks. It is pretty extensive. See all this? It is very extensive. And you can see everything from immigration stuff to all kinds of different facts. See, there's so much. It went berserk, didn't it? Hold on. It's because I changed my screen size. So, like this is a new one that.
So you give everyone an option to select what they want to receive, what kind of information.
No, this is all free. They literally just look it up themselves. Hold on one second. It did it funky for me. Okay, it's giving me issues. Hold on, y'all. Okay. Let me just do link tree. Because it's so big now, it has trouble sometimes. Okay, so the link tree is this big, right? And so it keeps going and going and going and going. And so there's information about the big ugly bill. That's what I call it. This is information for military people to know their rights. There's the link for Harvard free courses. There's immigration documents. But one of the things that I've done for people is, so this is where you sign up for workshops. But see this political resources. So when you actually go to that link, this is a Google Drive that I've created for folks. Let me make sure y'all can see it. You can. Great. So when you go here, right, there's Linktree docs, but like this is Medicaid. So I want people to be able to share information issues, right? So if people want to understand exactly what Medicaid cuts would do for them, then, for example, I can pick Colorado. And they have a graphic that they can use on social media that says, did you know, out of the 1.1 million children and adults on Medicaid in Colorado, 38% are children. 41% live in rural areas, right? It covers 41% of births. So these are all different graphics that I've created that are state specific that people can just go in and grab and put them on their social media, talking points. Did you know this information about Medicaid in your state? Did you know that if you're in, where is this? Louisiana, Louisiana Medicaid covers 64% of births. Did you know? So all of these are in here, and I created these, and they're available to anyone to use. But we've also done, so I stole this from Alec, Peter. So, you know how Alec writes a bill for representatives and just puts a highlighter and says, insert state here. So I did the same thing for people. So right here is the link to get your state's information. This is an email to send to your senator, and you can pull your state's information and your total Medicaid enrollees, your percentage of children, right? Percentage of births that are covered. Like all of that is here, and everything that's in yellow, all you got to do is plug it in, right? And now you have an email that is asking them to vote no on this big ugly bill, and why specifically for their state. I've done the same thing around immigration and other things like that. So the whole point is, I don't think that people should just be on TikTok, and this is my personal opinion. I don't think that people should just be on here to argue or debate, right? I think we should be on here giving people good information. So like all of this, you'll know what these are. There's a reason I can quote immigration law. It's because I've looked it all up. There's a reason I can tell you what people do and don't get, because I've looked it all up. And I don't want people to just believe me. I want people to go and read it for themselves. So all of this in this link tree. Yeah, Jinping, you're right. The end of this month will be 11 months that I've been going live on TikTok. Next month will be our 1-year anniversary, guys. July 28th. We will have been going live on TikTok together. But anyway, so in addition to the free workshops for everybody, the link tree is free for everybody. So people can go and get whatever information they want and they need. And then we do the workshops afterwards. So when you go to YouTube, I'll just show you. And y'all, I'm the Denny Cook pretty much everywhere. But so like if I go to YouTube and, oh my Lord, it said, girl, you got too many damn things open. So if I go to my channel, right, and I have playlists. So if I go to this playlist, then you will be able to see workshops and trainings. And you can actually go and watch, like this one is the Get Into Good Trouble. This one is the very first one. This is 7 Steps to Resolution. And then this is the Zoom, and it actually has the deck and everything in it. So what I want people to do is to become better citizens. I want them to be well-informed, accurately informed, so that they know how to vote, not just because they're a Democrat or a Republican, but because they know what the issues are. They know what the reality is about those issues, not what the news is saying, not whatever. I did copyright. I did copyright carve, Linda. Yeah, I did. I have a specific technique that I teach people to use to have difficult conversations. So anyway, yeah. But anyway, that's it. So that's it, Peter. That's kind of what I do in addition to going live on TikTok and in addition to my podcast. So, whoop. All right. So, folks, I know Peter's probably talking to them dogs or babies in the background.
I was already screaming at them. You knew it. You knew it.
I did know it.
So I'm going to repeat one more time, Danny. Come on now. I don't want you to waste your time. Come on now. You know what I'm going to ask, right?
I know what you're going to ask. Here's what I'm going to say. You see these grandbabies. You heard me say my daughter works 2 jobs, right? So it's got to be enough to cover coming to LA, because LA is more expensive than the South.
And you know what? I don't have much. I only have $10 million in the bank right now for my campaign, but you know, I'm getting there.
You are getting there.
Unfortunately, in California, well, especially here in Los Angeles, airtime is expensive.
Yeah.
So I'm only at 10 million. Jimmy Gomez, who is the person who I'm trying to unseat the incumbent, has 32 million. I need to beat his motherfucking ass. So I need more money at the end of the day. That's the bottom line.
And there's a way to get more money.
Get little by little. You know, everybody's doing their $5, $10 donations, and I'm okay with that because I am not taking corporate money at all. Zero.
I love that. So LaRonica said, "How can we donate?"
As soon as my website is up, because that's all I'm waiting for. I'm waiting for the state to give me, you know, you can't just do something like that. You have to get the authorization from the state to do that. So I'm waiting on them to tell me.
Yeah. So here's the deal, right? So, and I would love to when you get, because people are asking what district it is. What district is it, Peter?
34 downtown Los Angeles.
Okay, so once you get on the other side of this case, I would love to have you on a Zoom, and we can do an episode of the podcast where we talk about Los Angeles. We talk about District 34. What are the most pressing issues? What are your stances on them? What are your potential solutions for them? And things like that. So the podcast, I just started it in January. Almost every episode has been in the top 10% of podcasts globally. You have to reach 460 views within the first 7 days of putting up an episode for it to be in the top 10% of global downloads. And so most of my episodes met that standard. Yeah, so, you know, love to do you on a podcast and talk about those types of things.
And I would love to, because, you know, downtown Los Angeles is a very diverse. I mean, my district 34 is not just downtown. Yes, I live here. Yes, I'm a part of it, and I see it and I smell it. But it is what it is. And I'll tell you something right now. It is probably one of the most diverse districts. I mean, we have. I speak, and thankfully, I speak all the languages that are represented by all my constituents. So I speak to them in Korean, I speak to them in Mandarin, I speak to them in Ebonics. And I love saying that because sometimes people need to hear it.
Yeah, listen, you gotta talk to people in a way that they can hear you. You know, I ask people all the time, I say, listen, do you want to be right or do you want to be heard? Right? It's not enough to just be right about an issue. You girls, something unalived her in the game.
Somebody fell.
She didn't fall. Listen, that girl is gonna win me an Oscar. I swear on everything good and holy. Listen, you hear how quickly it's gone? This child right here, she gonna be an EGOT. I'm telling you. She gonna have an Emmy, a Grammy, an Oscar, and a Tony. She can tone it on like that. And then when I looked at her, she was looking at me out the side of her eye.
Maybe she needs a kiss with that side eye that she's probably giving you right
now. Yeah, look. You see it's gone away, right?
Yeah.
You don't even hear it. Yeah, no, she didn't fall. She didn't like something that happened in the game with her sister. That's all. Ain't nothing wrong with that girl. I can tell when it's a real cry versus...
And you know, Daddy, any parent knows a real cry from a fake one. So trust me, I knew it when I heard it. I just thought maybe she had fallen and whatever. She was just drama.
Listen, last week, right? That's what I was gonna say, Linda. The other day, I heard her cry, and it was her. Mila, Dominic, did you try to touch her?
I was making so she didn't feel bad.
Okay. Well, you can't help her. Mila, okay. Thank you. You're not hurt. You're okay. Appreciate you. Just leave her alone. Thank you. Because it just makes it worse. But she was in the bathroom and I heard her, but it was the real cry and I knew she was hurt. And I said, somebody take over. I got to go. And I jumped up. She had gotten my essential oils in her eyes. Hey, that is enough right now. I said enough. We're not doing that. Girls, Tutu's done. She mad at her sister.
She's mad.
Which she didn't get all of her nap out. She was up late and got up way too early because she heard me getting ready to go to the gym. Come here. Come on. If you gonna come. If you're not gonna come over here, quit crying.
Get her and hold her. Get her and hold her for a minute.
I know it. She'll be fine. Come here. Come on. And not a tear the first. Okay, you good?
Well, I left the game because Mila killed me.
Okay, well, didn't you kill her first?
I did.
I know she did. So you can't be mad, Bella. Listen, if you're going to kill her in the game and then she kills you in the game, you can't turn around and leave the game because you're mad because she killed you because you killed her first. Right? So either we're going to play together or we're not. Okay, you all good now? Okay, you're good. I cannot. Look, say hi. See?
Hi, baby. We love you. Get out of here. Stop crying.
You hear Peter? He said stop. Okay? Go play.
Honey, you are loved. Don't worry. Everything's going to be okay.
She is so fine. She is, listen.
She's beautiful, by the way. She's
Thank
gorgeous.
you. Listen, I have really great grands. I really, really do. Them girls though, it is either, it is either oil and water, right? Or it is like perfectly blended together. It's one or the other. There's never middle ground. It is either they are lovey-dovey and, hey, sissy, I'll do that for you. Or it is, it's one of the two. And it drives me crazy. Yes. So, but anyway.
And I learned that the hard way as a dad. Let me tell you something. Girls are like that. They just are like that. They just are.
You know what I said? Small. These two make me glad I never had a sister.
You don't?
No, I have two older brothers, and these two make me very glad I never had a sister.
Oh my God, that is so funny. I have 20 brothers. I'm the youngest of the 20.
I cannot with you. Yeah, see? Well, we know that your family is not the reason we have a declining birth rate.
Well, not from Spain. And I used to get the shit beat out of me all the time. It was a fist fight every day. If there wasn't a fist fight, it was not a good day. Something was wrong.
Yeah, see? That's too much for me. So this is my thing. So the argument before Breyer on Friday, what is that? Yeah. What is that in reference to?
It refers back to the original arguments that were made in the 36-page. And that's unfortunate because what it's going to mean is that I think it's a preface that the Ninth Circuit Court. Hold on a minute, you motherfucker! Get on here. Sorry. That was Mateo acting up. Mateo's my fucking brat dog. I can't with him. Anybody want him? He's a purebred Pomeranian. I will give him away to anybody who wants him. I will give him away. I don't care. I'm done with him. He's 7 months old. He's a pain in my fucking ass. I don't want him. He is it.
So you think the reason that it's a continuation on Friday with Breyer is because today the appellate court may side the other way, and then it's going to go Supreme. Is that what you think?
Yeah, and the Ninth Circuit already had deference to that. They were talking about the judge's orders, and they were literally citing specific sections. And I was rolling my eyes because I was thinking, "Oh my God, we're going to have to go back and re-argue this," because the 36-page argument that Breyer submitted was so very clear about the overreach of the federal government that it has to be readdressed. And unfortunately, it will come there with instructions from the Ninth Circuit, which is what I'm worried about. One of the judges there looked like a fucking idiot. He was just like, I don't even know what I forgot his name.
Miller. I know who you're talking about. Miller.
He was just like, whatever. I was just like, I can't.
Yeah. So here's my thing. So my thoughts of one of the things that I was concerned about was, sometimes when the judges make a ruling like Breyer did, and it's so clear, but it gives the plaintiff more than what they originally asked for. I always get concerned that the appellate court is going to trim it back, and kind of say that the first court overreached and overdid. And so I always get concerned when they give you way more than what the original argument was. So I was concerned about that as soon as I read Breyer's order.
Well, Breyer's order was very broad, and it was.
That's my point.
Yeah, I get it. I hear you're being heard. I hear what you're saying, and that was a bit of concern for us, in spite of the fact that it was 36 pages, but it was very well detailed, and so his clerk made sure that all those points were made, and that's unfortunate for us who thought we had it going on, but no. As soon as I got back to LA from that hearing, I found out that that we had to go before the Ninth Circuit. Here we are. And now, after having had this hearing today, I'm not optimistic about it, to be honest with you.
Well, we stay optimistic around here. We do. And I'll tell you why. We do not speak the things that we do not want to happen.
Well, you know what I'm looking forward to? A good fight. And so when we have to go before the Supreme Court, like I said, I'm the team warrior. I will go there and run my mouth, and I do. Yeah. And I have.
Well, I figured we were going to the Supreme Court no matter what.
No, but the unfortunate thing is that, like I said, if I'm the one, I'll be taken off the team, because if I'm the one who has to go before the Supreme Court, as I expect to, but if I'm taken, it's because I'll be taken off because Kagan and because Sotomayor will have to recuse themselves. That's two of the most liberal judges.
Yeah.
And so get out of here. Those women, you know what? The same way I listen to you, I listen to them. And it's ridiculous. And we have major conversations with them. If you think that you and I have tame conversations, let me tell you the conversations I have with these women.
Yeah.
They are ridiculous.
The reason he's saying they would have to recuse is because he knows them personally, and so they would need to recuse themselves from the case.
Right.
Yeah, which is what that you should do whenever you are an ethical judge. We have seen cases where I believe Alito and Thomas should have recused themselves, but they haven't, right? But it's also because they don't have the same ethics as other judges do. So that's my opinion.
That's right.
Yep. So agreed. Yeah. So I think that this is where we're at. We'll wait for the decision. It doesn't matter. The decision today doesn't change anything, because I think it doesn't change anything.
Nothing.
Yeah.
It's nothing.
Yeah, because you're still going to be before Breyer on Friday. And even if they sided with you all today, then they would still stay it, and they would be immediate relief, and they would say before the Supreme Court. So really, today's decision doesn't change anything in terms of the overall outcome.
No, it does not. You're absolutely right. And that's the end of it, because that's why I'm saying I don't know about this panel. I'm not hopeful. We haven't heard the result yet. We haven't heard the order yet.
Right.
But I'm not hopeful. I am not. I think we're headed to the United States Supreme Court. And you know what? I probably should recuse myself. I should probably just step down and just tell everybody else what I would argue and write the brief and everything. And then they can argue it.
But not the person that argued today.
I'm a stubborn motherfucker, and I have a big mouth, and this is LA, and LA has to have a voice, and that's the end of it.
Yeah, but here's the thing, right? Let me just say this. We need it to not be the person that argued it today.
It is not going to be him, because, like I said, I'm the senior person with the. I've been to the Supreme Court locally in my lifetime 39 times. Okay,
holy jeez.
There's no way, and I've never lost a single case. There's no way that they're going to say, no, we don't want him. Get out of here. They're going to pay me my hourly rate, and they're going to be happy paying it, because it is what it is.
Right. We love that. So, all right. So I think everybody should feel fine about what we've seen today. I did say nah, I did. And the reason why is I feel like when you are in these court cases, so here's the thing. Here's what the Trump administration and the Trump campaign has always done well. They know how to sound confident even when they're lying, right? They know how to sound like they believe what they're arguing, even if they know it's a bullshit argument. And what I needed from today from the lawyer that argued this case was to sound like more confident in the arguments, in the points, because they were strong points. But I needed him to sell it a little more, because I didn't believe him that he believed it.
Yeah, unfortunately, I got overtalked by the partners involved, and so Skippy, and I call him Skippy. Skippy went up to bat, so Skippy ran his mouth, and he was good for a minute. But come on now, if you really want a seasoned voice, you got to put the seasoned professionals up front. You can't put Skippy at back. Get out of here. This was important to argue. These were points that needed to be made today and solidified. And unfortunately, I did not have that feeling from him at all. And I wish I would have gone to the mock hearings yesterday, but I was en route back to Los Angeles from being at the failed Trump parade on Saturday. So I'm sorry, I was tired for Skippy. But whatever, I didn't hear his effing arguments, and had I heard them, I would have shut him down. I would have been the first. And I'm hoarse right now from doing it, because I've been saying it to his firm and him
All
for hours now, so I'm done. I'm done.
Well,
with
go watch it on YouTube. You know, the Ninth Circuit, you can watch it on YouTube. That's what we just did.
It's there. It's there. And I told, and I hate to be, I don't want to sound racist here, but I hate to say, listen, when you let Idaho run the show.
Oh, Lord, stop it. Yeah, you need somebody to help you on your campaign. We need to polish you up a little bit.
No, I don't need polish.
Yes, we do. Just a bit. Just a smidge.
Sometimes the truth needs to be
told. It can, but you can tell the truth. But here's the thing. You can tell the truth in a way. Because, like, for example, I will say things like caucasity, because it's true. Sometimes the caucasity of people is amazing, right? But it's just the way you got to do it. So, like, in my personal opinion, I will tell you this, real talk. I believe that there are a couple of very strong Black Democratic politicians in this country who have people running them, whether it's their campaigns, whether it's their offices or whatever. And sometimes I wonder if those people aren't internal saboteurs. Because of the way that they do things. I've seen it close up, and it makes me a little leery about people have to be very selective about who they surround themselves with. And I'm not sure that they always do that.
Well, that might be so. And you're right. I mean, that is a finesse of the political system that we all are unfortunately have to get accustomed to when we're in the arena, and I'm in it now. So yes, you're right.
Not you doing a Teddy Roosevelt quilt.
But let me tell you something. I run my campaign the way I run it because I'm very, very passionate about my respect for the people that I speak for, because they depend on a big voice, and if they want that big voice and something slapping down on the table real hard, they're going to get it. They're going to get it from me. They're not going to get somebody who is not about them, because this is not about me. If it was about me, I would never do politics. I make more money doing what I'm doing as a living, and I could retire with this money right now.
Right.
It's about right now. It's about what can I do? What's my legacy?
They are hilarious.
Besides my kids,
yeah,
I have a legacy that I want to leave, and my legacy is it's about Los Angeles. It's about the residents. It's about the people that I speak to every day. It's about Doña Maria, who's down the street, whose cart got closed down. Her fruit cart got closed down because she was an immigrant, and so unfortunately, her husband was taken away. She was not, because she has a status here in the United States. It's about everyone who has been subjected to anything, and it's not just about the immigrants. It's about the unhoused. What about the people who have nothing? Who have nothing and need help? Get 100%. Out of here. And it goes across all races.
It does.
It goes across all barriers. I don't understand why people just ignore this. It is a major issue, and we need to do something about it. And we need to stop talking about what we're going to do and do it. Just do it.
Yep, 100%. Lil Linkle said, Danny knows how to cuss you out, and you'll say thank you afterwards. But here's the thing. So, like, the way that I would. Okay, so there's a way that so this is something that I say to people all the time. So when you are talking to people and you need to get their buy-in, what you say to them has to do 3 different things, right? It has to touch them, it has to move them, and it has to inspire them, right? If it just touches them, it'll be temporal and it'll go away. If it moves them, it might stick for a minute, but eventually it fades. When people are inspired, right? They don't need any external motivation. When people are inspired, that flame is lit internally and nobody can blow it out, and they don't need anybody to light it for them, right? And that's the difference. And so when you touch, move, and inspire, then people actually hear you, and then they go to take it on. And so that's one of the things, like when I do workshops and I facilitate workshops, like I did the Michigan Democratic Rural Caucus, and I did the their summit, and then I did the Virginia one. But in Michigan, I facilitated 2 breakout sessions. And so one of the things that I work with people on is being able to articulate their why in 60 seconds, 60 to 90 seconds. And then we literally work through it. Like, and I asked the room, did you believe them? Were you touched? Were you moved? Were you inspired? And then I work with people on how to kind of tap into that and be able to say it in the way that that resonates with people. Yeah. That's what's necessary.
Okay. Well,
okay.
You know what? You just, you know what I'm going to say.
I do know what you're about to say. I do. And I hear you. You are heard. You are heard. Yeah.
Am I being heard?
Yeah, you're being heard. I hear you. 100%. I hear you. Yeah. But no, so like the story when you talked about the lady with the fruit cart, what's her name?
Doña Gloria.
Okay. So when you talk about Doña Gloria and you talk about what your legacy is, right? There's a way to do that because you're doing it now, but you are, I would say, listening to you say it, you are about 2 steps removed from the place where you need to go because it requires vulnerability. And you're about 2 steps removed from where you need to go to be able to touch into that. And you've got to tell the story as it relates to you, and how it resonates. And so, like, one day we'll have a chat when you get on the other side of this court case, and we'll talk about it. I did it with a girl, just literally on the fly, and she was telling her why, and she got 1 step removed from where she needed to be. And I said, "You're almost there." And I just gave her a little bit of coaching. Next thing you know, she told the story. She was in tears. People in the room were crying, and I said, "See that? Now they believe you. Now they are touched. Now they are inspired. Now you're ready to do work. Everybody has bought into what you're saying." And so like, that's what we are missing because very few people today like to be vulnerable. But vulnerability is what inspires people, right? People just don't want to do it themselves. When we see somebody being vulnerable, we're inspired by it. But we don't want to do it ourselves, and we've got to be able to articulate it in a way that brings people together.
And you're absolutely right. And unfortunately for me, and you're right about this, I've been trained in a different approach. Vulnerability is never anything you want to expose. It's about kill and win.
Except it's not. And I'll tell you this: you will actually win more with vulnerability than without it. Like what you're talking about is exactly what Trump says. Yes, in court. I promise you. Listen, I went to court and won my own court case, and I'm not even a lawyer. I'm just telling you. There's a way to do it. Listen, vulnerability isn't weakness. You can be vulnerable in court, and be unaliving someone at the same time. You can, and it's the most powerful unaliving when you do it with vulnerability. Because when you do it harshly, it can sometimes be a turnoff. But when you're able to do a soft, listen, it's almost, okay, so it's almost the difference between walking into a room with 1,000 rounds and just, right? Or just being able to brush by somebody and do a little tap, and next thing you know, they're on the ground. Right? That's the difference. That is the difference.
Danny, you know, I appreciate hearing you, and you're being heard. You are, but you know,
we just disagree.
40 years for me, and not a losing case.
And I'm not saying that your way is not effective, but what I'm saying is the difference is you're arguing in court, and now you're going to be arguing in the court of public opinion when it comes to an election.
And therein lies the difference. So yes, you're absolutely right, and that's one. To your credit, that's one of the things that I need to learn is just soften my approach a little bit, because quite frankly, I'm coming off a little strong, and I can. Yeah. And there's no way somebody's going to come up to me and tell me shit and me not saying something right back, because I will. But I've even been told this by my partners in my firm. They're just telling me, okay, since you're going into politics, you need to soften your blow a little bit. You need to soften the landing, because right now you're serving it up super hot.
Yeah.
People are going to be turned off by that.
Yeah, you just got to make it palpable, right? You know?
That's it. And you know what? You want the damn job or not, I'll pay you. I'll pay you well.
We will talk, Peter. We will talk. 100%. We will talk.
I'll pay you way, way beyond something that you probably think that you're not worth. But let me tell you something: you are worth it. You are worth it. And so, I'm just gonna say that right now until you and I have a particular
Conversation. We can do that. We can do that. Okay, so here's what I'm going to do, folks. Is I'm gonna round this out because today has been another like 6-hour day for us together. Peter, I appreciate you for coming back on Tuesday exactly like you said that you would, and giving us your take. I love the fact that you hear our observations about what transpired in court today, and giving us just like that foundational knowledge that no matter what happens today at the Ninth Circuit, we're back in front of Breyer on Friday, and probably headed to the Supreme Court either way. So it's a marathon, not a sprint, but we're okay, right?
And we are always going to be okay. So just relax. Just take a deep breath.
Yep.
Everything that happened at the Ninth Circuit today is nothing. It's a big nothing. It's a nothing burger.
Yep.
So just relax. We will just go before Breyer, and guess what? If we have to go to the Supreme Court, we'll go there. And maybe not me, because I have to look out for the best interests of the team.
Yep.
I'm the liability. Although I'm the smartest one on the team, I'm the liability because they're probably not going to let me go there if 2 judges have to recuse themselves.
Absolutely not.
And they need those 2 judges to vote.
Yeah, you just help write that brief and then make sure somebody that can argue it well
It's okay. I can sit back and let the younger ones, but they're not going to be untutored. They will be listening to my ass all day long.
Absolutely, as they should be. So I appreciate you, Peter. Of course, you are welcome back. Hopefully, we will see you on Friday. And even before then, because I will be here again. So I'm gonna.
I don't know when you're on. When are you on?
So I typically am on in the mornings. So your time it would be 8 a.m. to 11 a.m. And then I've been. Yeah, I'm on the East Coast. My daughter is in LA, but I'm on the East Coast. And so I'm normally on my time anywhere between 10 and 11 a.m. to about 2. And then I typically come back and do about a 5 to 7. Yeah. And if you join the Discord that I have, you can find it in my link tree. If you join Discord, then you'll get a notification every time I'm live. That's all you got to do. Okay.
Well, thank you so much.
Yeah, I appreciate you.
I appreciate you giving me some airtime. I'm sorry that I took up so much of it because it sounds like I did. I mean, I don't know. Is there anyone else here? I'm here. I see only my picture and your picture.
Yeah, no, because there are other people that requested up, but I haven't brought anybody else up. I need to look at something. Hold on a second. 88 kids removed. I can't, y'all. So did you all see that? Did you all see yesterday that 88 children were removed from a church camp after reports of abuse and endangerment? Did y'all see that? Shekinah Glory Camp. It was 9 hours ago. I missed it because of everything else that was happening. And it's in Iowa. They were placed in, so 88 children placed into child protective custody following reports of child abuse and endangerment. It is Shekinah Glory Camp in Iowa.
Yeah, I heard it and I knew about it. Did I do anything about it? All I can do is call my friends up in Iowa to figure out how we can help these kids.
Yeah.
Because I think somebody called up and lied. Because that's what it sounds like to me. How are all these kids being subjected to all that? Get out of here. There's no way. There's no way.
Assisting individuals, and I need to read more so that I see exactly what's going on. Because here's what I'm saying: having been somebody that was brought up in all kind of Bible camps, you'd be surprised. So I just need to read and find out. Because it says multiple agencies were involved in a large 2D operation. Blah 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 blah. And it's supposedly people that are suffering from addiction. I don't know. Anyway. I just saw it. So we'll go from there. But anyway, y'all see the ADHD. I just was like, ding, 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 ding. All right. I appreciate everyone. Peter, you as well. I'm going to be back tomorrow morning, Shekinah Glory. Yeah. So Rachel, that's the thing. So Tennessee has had some issues with, we had an issue with a judge in Tennessee that was sending Black and brown children with extreme sentences at the ages of 8, 9, 10 years old. We've had that issue. Rutherford, yes, Rachel, we had Rutherford. We've had a lot of different things in Tennessee, so it's a bit of a shit show where we are. But anyway, I will see you all tomorrow morning. Hey, Dr. Emmy, good to see you. I'll see you all tomorrow morning, at least at 11 a.m. Eastern Standard Time, potentially 10 a.m. Eastern Standard Time. Just depends on how soon I get my ass going. So, Peter, thanks to you again. I will see you whenever you join. Thank you for joining today, and we will definitely see you Friday, if not before.
You will. Thank you.
All right.